On 21st January, Lordships were pleased to direct for it
Next
to be
Monday.
grateful, my lord.
Next. 5th of March. All right, start.
My lords, may I please mention a matter which was listed last Friday. The order records, we were directed to consider the representation made by the petitioner for compassionate allowance. Your lordship, the relevant regulation is regulation 31 of the pension regulations. However, the order records that regulation 20 of the service regulations. If correction could be made to that extent.
All right. Yes.
Much
Okay.
Tomorrow there is a case. Tomorrow there is a case at serial number 45 fixed at 2 p.m.
2 p.m. before us.
My lord, I have obtained the consent of Mr. Ranjit Kumar. Except tomorrow, not any day after or any day.
What matter is that?
Lord, that is Jamabandi matter of Bihar.
You want some accommodation?
My lord.
Sure. No issues. After 2 weeks, we will say. Yes, Mr. Bharat.
Item 16 tomorrow, my lord. There is a parted matter.
1-6.
1-6. Accommodation for this week.
1-6 is a part heard? How?
Yes, ma'am. Mr. Luthra is this matter.
Which matter is that?
PD Rajkumar versus M. Gunashekar. That's CCTV matter.
You see?
That's CCTV matter.
Oh, CCTV matter. It has become part heard, is
It's
it?
become part.
Oh, CCTV. What do you want?
1 week accommodation.
All right.
Inform.
You ask the other side.
Yeah, we inform.
Lords, may I mention item 36, Milords, may permit me.
Today?
Yes.
Wait. Mention today's board.
Your Lordships, may I please mention item 32? This is listed tomorrow. This is on account, I'm speaking on account of the arguing counsel being taken unwell.
You inform the other side.
Yes, they are present online.
Note kar lena.
Much.
Mentioning a matter which was listed on Friday. Manoj had issued notice and made it returnable. We had sought for liberty to serve the standing counsel, which that has not been recorded in the order. Whatever my lords direct, if
usko record kar lena. It doesn't matter. What is there hardly? You serve on the standing counsel. What's the deal about it?
One small mentioning. The other day I had mentioned, that if they don't implement the order, somebody should be present. But unfortunately, what is recorded is assistant managing director instead of assistant general manager.
Assistant general manager.
I'll just point. I'll give that order to you. Para 5, that's the only correction.
Thank you.
For respondent husband, my lord, section 9 petition, my lord, wife is seeking transfer, my lord.
Yes.
From Bihar to Delhi, my lord.
Yeah.
But
Yes, we are already pending. One if child is also there.
I'm for
Girl
respondent.
child also. Very good. Thank you. Then 2. We'll transfer it.
Your Lordships, I have something to say.
My Lordship, this is a divorce petition. I am seeking transfer of divorce petition from Vadodara, Gujarat to you.
Your Lordships, I have something to say. I am saying, Your Lordships, this transfer petition is filed on the basis of inconvenience of the parents of the wife. Both the parties are living and working in the US. In any case, the evidence will be led through video conferencing. The video conferencing.
Both are in USA.
They are living and working in Your Lordships. The matter could have been settled. I was willing to offer a very, very reasonable sum.
But what can be done? That's,
Yes, Your Lordships.
No,
My Lordship,
That's
we don't step into that position.
But Your Lordships, even my parents are old. They are senior citizens.
My Lordship, there is already one case.
Don't cross talk.
Sorry, my Lordship.
They are also suffering from various ailments. I have written the father suffering from the father's diabetic and has undergone multiple.
498 is there.
But Your Lordship,
about that?
Your Lordships, I filed for quashing in Allahabad High Court.
That makes no difference.
Yes, Your Lordship. So therefore, divorce is separate, Your Lordship.
That doesn't matter. Oh, you have to go there for 498A.
But Your Lordships, the divorce, what I have found out is that the video conferencing facility in Baroda are far more developed as compared to Varanasi, and the evidence will be recorded through video conferencing. Both are living and working in the US.
We are motivated morely towards the fact that there's already criminal proceedings.
Yes, my Lord.
But Your Lordships, like fake proceedings have been filed with the
Transfer it. Women.
obliged.
Thank you. There's a child with the mother. Service कब complete है इसमें?
May I, Lordship?
Somebody
Lordship,
is
sir, this is my
Yes,
plan
tell
for the
us.
petitioner.
Your
My lord,
Lordship, I appear for the respondent in this case. Your
my lord,
Lordship.
the respondent, my lord, there is a failed effort of mediation, my lords. We have made our effort in the, my lords, we have made our efforts in the mediation, my lords. Unfortunately, got failed
Mediation
marriage.
didn't work for you?
Yes, Your Lordship. Lordship, there is a my lord's marriage has happened, my lords, in 2002, my lords. Thereafter, my lords, the child was born in 2003. My lords, my lord, the mediation got failed on account of monetary aspect, my lords.
Whatever, we can't help it. We will not get into the mediation.
My lords, my lords, the
We
dispute.
now transfer it because the child is with the mother.
Yes, my lords.
Transfer it. We'll transfer it.
I'm grateful, my lords.
Yes. Item 4. We are transferring item 3. Huh?
Your Lordship.
4. What's the one? No, next one. 4 one. Huh? Karkaduma se Faridabad. Huh? Maybe very 50. Yes.
I am muted. Yes, kindly unmute me.
We
Yes,
can,
Lordship.
Yes.
Yes, Lordship, in item number 4, I am appearing for the petitioner wife, Lordship.
Faridabad
Petitioner wife is
and
unemployed.
Karkaduma, hardly any. You can just
Lordship,
travel for a couple of hours.
Agreed, Lordship, but the issue is that the petitioner wife is unemployed, Lordship, and the husband is very violent. So, Lordship, she is afraid to go and she is also unemployed. So, kindly request for transfer, Lordship.
It's not very far away. Which year is the suit for?
Lordship,
the divorce file? Which year was it filed?
Lordship, this marriage was done in 2022, and Lordship, divorce was filed. Lordship, let me check it.
It's all right, 24 only, no doubt.
Yes, Lordship.
It's all right, it's just nearby, we don't need to transfer.
Lordship, I
Just
agree
next
with
door,
Lordship.
you don't need
But
to.
but Lordship, husband is very violent, Lordship, and girl is unemployed, Lordship. So kindly.
No 498 and nothing, just a divorce case for him. That's all.
Lordship, few other cases are also running in Faridabad, Lordship. So he have to come.
What are you never mentioned about anything? What else is pending in Lordship?
Lordship, in previous date, advocate of husband appeared in court and they said that they will find the counter.
What are the other cases pending?
Now, but they have not done that.
What are the other cases pending? You have not indicated anything in your transfer petition.
Lordship, kindly give a date. I will indicate that, Lordship.
What are the other cases? Tell us at least.
I will file the additional document, Lordship.
At least tell us what are the other cases.
Lordship, other cases is dealt by other advocate, Lordship. So I am not aware much, but I will take the details and
Thank
I will
you. Dismissed. Don't invent things. Next.
Case balance is enough
Mumbai to Jammu.
by the wife.
Lots parties may be referred for mediation, my lords.
Mediation.
Yes, my lord.
But otherwise, quite a few, it has to be transferred because
Lords,
EV cases.
Lots may refer the party.
Why don't we transfer it and then ask the mediation to be done at Jammu?
Lots, let them.
Can be done here also.
We'll settle it.
We'll settle later. Anyway, we always hope is always
Yes, my lord.
the best thing to happen in life. Mediation referred.
Consider BC because she's in Jammu.
Yes, that's part of it.
I'm grateful.
In the meanwhile, we'll file the counter also.
Do that.
I'm grateful.
Item 6, I have the same request.
This is coming after notice.
I've entered appearance. I'm requesting
Well,
to be referred to mediation because there are 2 children
Because
also.
if somebody can be appointed, Milos, because the nature of matter is such.
Yes, I.
Because they both are
appointed as what?
as a mediator.
Yes, I am requesting to the same.
Or
Let us senior.
a senior counsel, maybe if they agree to
Senior
it.
mediator.
Very well.
Published.
Senior experienced mediator. Yeah, where is this from? Which state is this?
Milos, it is
Gujarat from Jabalpur. From
Ahmedabad to Milos, Jabalpur.
These are Gujaratis.
They both. Yes.
Yes, Milos.
The petition.
Both are not Gujaratis, Milos.
The petition.
One of them is a Gujarati.
Next.
Obliged.
Obliged.
Lords, I am appearing for the petitioner wife. I am seeking transfer of the divorce petition that is filed in Gujarat, Vadodara, Gujarat. I am residing.
I am appearing for the respondent entering appearance for the first time. Lordships may give me some time to file a counter and a paper book may be supplied to me.
All right, we'll have it after 3 weeks. Next.
May I please?
My lords, I appear on the pet 5.
Kindly have it on some other day because my counter is ready. After notice first time it is coming during the course of the court, I will find.
I'm not being supplied any copy.
Supplies.
During the course of the I will do it.
Sure, okay. Counter affidavit shall be filed during the course of the day. Come a copy of which will be served on the petitioner. List after
Interim orders, my lords.
Interim order to continue.
Obliged.
Yes.
Obliged.
Yes.
But the complaint under section 420,
The investigation has already been completed, other accused has been granted bail, charge sheet has been filed.
Promise of a job is anticipatory bail. Anticipatory bail. Was to be granted है दूसरे को issue notice.
My lord.
Interim protection.
My lord.
Seeking a passover in this one, my lords. It's a fresh matter.
Yes. This guy is a police chair. He's a police chair. ये गड़बड़ करेगा रे He has been there for 3.5 years, right?
3 years, 9 months. May I only request a returnable date?
Your role is a little more intense.
Similar role.
810's role is a little
Similar role, your lordships have granted bail to
granted.
the other two.
Issue notice.
May I request for a returnable date?
Yeah, returnable date.
I bow.
Lord, I'm making a statement at bar that I will not proceed with the contempt petition in item 11.
My lord, I would request, my lord, my learned friend is very fair, but my lord, our statement may perhaps not prevent the court from, my lord, the proceeding. That's the apprehension. Your lordships have issued notice in the main SLB.
Notice.
In the main SLB.
Only to the extent of payment of costs, Mr. Solicitor.
No,
we didn't grant you a stay even on the first day.
No, my lord, that your lordships, my lord, issued notice on that.
No, the interim order, if you see, confined it only to the payment.
Lord,
No, but the notice is for entirement. I can assure your lordships did not refuse the stay. I immediately prayed for the stay, thinking that there may not be any precipitative action.
We specifically, we didn't grant you stay is what we are saying.
No, correct. No, my lord, your lordships.
Means that we intended that you must give him the.
My lords have indicated that obliged.
You have intended that I think, yeah, prima facie, I will just 1 minute. Prima facie, I think it's right. Examine करके देखें.
Lord, your lordships may hear the main matter whenever it comes. In the meantime, my learned friend's statement will be sufficient.
Okay. Learned counsel, we record the learned statement of the learned counsel for the respondent that he will not press the contempt proceedings pending disposal of the special petition.
I am
grateful. This matter for final disposal.
I am thankful to my learned friend.
Fixed, my lord. My counter is ready. It will be filed within.
Please file.
The date may be fixed.
We'll fix a date. 2 o'clock.
Obliged.
Grateful to you.
Please, Your Lordship. Lords, under UP Right to Education Rules 2011, Lords, the outer limit of the income is 1 lakh rupees. Great.
On stay. No stay.
Please, Lordship. Yes, we have admitted the student.
Very good. Very good.
Great.
Okay, learned counsel for the petitioner submits that the student has actually been admitted into the school for the purpose of deciding the issue, deciding the principle arising for consideration, issue notice.
Great, Lordship. Great.
Final.
Your Lordship, I am for the petition. I am for the petition, Your Lordship.
Item
13, Your Lordship. I am for the petitioner. It's a case RTA, Your Lordship. In this case, I am the owner of the mobile number for which I have sought information under RTA. It has been confirmed by the respondent. It is recorded. I am the owner. So, according to the Constitutional Judgment of 2019, personal information within the Act 81J of the Act is somebody else's information. And it is a third party information. There are two
it's true. All that they are asking is identity of yours.
Under the
tomorrow I will go and then I will ask Mr. Arun Kamalations. I am Arun Kamalation. Please give me all the.
You Lordship, I respect you.
Verify whether I am Arun Kamalation or.
They have confirmed. I am the owner. They have confirmed it. They have confirmed it. They gave in writing that petition is the owner of the mobile number.
The identity they will do it.
They have confirmed it. That point is already there.
They didn't deny it to you.
Your Lordship, I have to travel 30 kilometers. I am a retired officer, Your Lordship. Your Lordship, 30 kilometers. Under the statute, there is no provision to appear in person.
Have you travelled to come to Supreme Court?
Your Lordship, I am advocate. I am signing there only through affidavit. Your Lordship.
Give information about your identity is the simple thing. I don't.
Your Lordship, they are asking to travel 30 kilometers. Your Lordship, travel 30.
No,
Your Lordship, under the statute.
It is for protection of the individual itself, or else it will be misused.
It is beyond the legislation, Your Lordship. My respectful Swami, it is beyond legislation, Your Lordship. The RTR rules 2012 says the information can be given on post, Your Lordship, on email also. They are taking the charge, Your Lordship.
It is your all data information.
It is my own mobile number, Your Lordship.
Thank you, sir. Thank you,
Your Lordship.
Next.
Lordship.
Next. 14. Dismissed. 14.
Great.
14.
My lord.
Yes, tell us.
Yes, my lords. My lord, the short issue is whether the
delay. Your request is dismissed on the ground of delay. There is no issue.
188 delays, my lord. Yes, my lord.
That you should tell us.
My lord,
your case is not decided on merits by the High Court. It was dismissed on delay. So tell us about
dismissed on delay, my lord. It was dismissed on delay of relying upon Surma Manjari, my lord. There was 180.
Directing that regularization to be appointed.
Whether the regularization is retrospective or prospective.
Individual case, sir, it's all right.
My lord, let it be not be a precedent, my lord.
SLP dismissal on the ground of delay is no precedent at all.
Leaving the question of law open.
SLP dismissed on the ground of delay. No, just say this because High Court dismissed it on delay.
Yes, my lord.
24 days. It is worse here. 324 days here. Dismissed on the ground of delay.
Because the learned seniors on VC.
Yes.
Without framing any substantial question of law, and the second appeal comes up for admission, straight away the appeal is allowed, and the judgment of the dictate of the trial court has been reversed. Your lordships have laid down that without framing substantial questions of law, no appeal can be entertained under section 100.
Issue notice. Next.
My lord, there is a delay. I'm sorry.
Notice.
Not out of 82 decimal area, 6 decimal was recorded as Abadi.
3,223 days delay.
Plus delay.
Not 1 day, 2 days.
Review was pending.
There was a review from the review order, but it is within time.
And out of 82 decimals, 6 decimal was recorded as Abadi.
Yes, Zamindar.
But therefore, in view of the Supreme Court decision, in UP State Sugar Corporation, that I am entitled to benefit of that. In section 9, it's on the findings recorded by the High Court has noticed that 6 decimal was Abadi. If that is so, it shall be deemed to have been settled in view of section 9. That's what State Sugar Corporation holds balance.
How does it, what is your right? You originally it was a Zamindari land.
No, Zamindari land is settled in view of section 9. Of a Zamindari and person who is the Abadi, it shall be deemed to have been settled. That's what the Supreme Court says, madam. Section 9 also says.
But what is the finding on possession?
But I was in possession by the Abadi.
The other side, sale deed is executed in 60s.
But if Lordship, sir, please additional evidence filed under Article 41 Rule 27. Yes, sir.
Both concurrent findings of the first appellate and second that you failed to prove ownership and also failed to prove possession also. Obviously, possession might not have been with you because that other person is claiming a occupancy.
What I respectfully submit is this, but if the Khasra entry records Abadi of mine. But I am there, suppose for some time.
They are setting up a sale deed of 63 which includes the entire area.
1359 facility is immediately preceding the date of.
Right, but on the date of institution of the suit, you are out of possession for more than 12 years.
But that's the
They have a sale deed of 63.
finding blood, my house was there, nobody says that house is that.
Arise for consideration.
Blood, if Lordship, sir, please to see the findings recorded by on page 9.
So your suit is of which year?
A perusal of Khasra
81 suit.
81 suit, 63 is the sale deed in their favor.
Blood, if Lordship, sir, please to see the finding on page 9. A perusal of Khasra aforesaid shows that an area of 6 decimal. My house.
Thank you. Thank you. SLP dismissed. Next.
Some 17, short delay of 82 days in filing my restoration application minutes against the dismissal of a second appeal has not been condoned by the
Issue notice.
Very
2 days delay.
Yes, but very grateful.
Ask them to restore it. Possibly.
But you have actually given no explanation.
Yes,
Nothing at all.
I'm also permit me to file an IA explaining the delay because even before
DM's order under 141 is what you challenge.
I'll file an application explaining the delay.
Possession की ही बात है.
I'll file it. Very grateful.
Mate list. I am an illiterate person. I got a sale deed for 25 cents from the husband of the first respondent. What happened? I don't know what happened in the registry. My original sale deed has been seized by the police in a criminal case. If that original sale deed which was signed both the parties, in the register sub-register office, only transcript is added.
There's a lot of golmaal in this.
That's what that is subject to outcome of criminal case. I am.
I could we think that.
It's a land single. Clear it,
Let's look into it because how interpolations can.
That's my answer is how the single judge has handled. Observe this matter. The land single judge.
But there is one fundamental issue regarding jurisdiction. Now, how can the writ court go into a question of manipulation in the original document?
No, that's what the.
So you are the writ petitioner.
No, first writ petition was filed by them. Got a direction. Issue a certificate copy. Taking that as a certificate copy, they corrected and issued a certificate. That's why I went second round. First round I did not go. That's a problem now.
So you are the second.
Second round I went there because that's why writ court should not waited for the correction in the trial court. It's criminal case.
But ultimately it goes to one question is there, Jen. How if you direct that sale deed to be modified?
No, what I am saying. Subject to outcome.
Saying a point in your favor.
Yes, I am
notice.
Correct. I am obliged. I am obliged. Grateful. I am grateful.
This matter with C.
Grateful.
19, there was
This matter was
mentioned for an adjournment.
May only request your Lordship, this matter may be listed on Friday before the.
We'll see. Next.
My lords, please, my lords, today there petition become infructuous because in terms of the page 59 and 60,
file such.
I've already given the
Interim order 443 days.
more than 1.5 years.
Dismissed as infructuous.
Let's
not spend more time on.
Page 59 and 60 is relevant. Today they are asking for the interrogatories that we have supplied today.
Whatever it is, it's an agency.
Page 59 and 60 is the
infructuous is what you're saying. So nothing remains of this.
Trial has been halted. That some directions to the High Court.
Don't. Thank you.
Today we have already supplied the interrogatories.
The petition on this. Page 242, my lords, is the agreement. The signatures on the agreement, my lords, are admitted and referred to the forensic. Now, despite that, the court finds, my lords, that the payment also is not proved by me. Agreement, my lords, at 242 refers to 1 crore 85 lakhs, 1 crore 35 lakhs having been paid. 5 lakhs is by check. There is an endorsement at the bottom of page 244, my lords, and these are both admitted signatures.
All findings seems to be, we are just checking up from the judgment because they are all findings of fact. So it's a first appeal only.
Yes, it's a first appeal.
I think those findings of your facts and apart from that seems to be consistent. Everything is in the.
My lords,
from the agreement of.
Very importantly, my lords, the first defendant who is the owner of the property in the written.
R3 had a right to sell it all.
D1 admits it in the written statement. That's the crux, my lords. I'm grateful to your lordships. D1 in the written statement admits that pursuant to an MOU, the rights vested in D3. And D3 in the written statement makes a bald denial. Makes a bald denial in the written statement, my lords. D3. His signatures, which your lordship see at 10.
But who this consideration was paid? What is the mode of payment of the consideration?
My lords, 5 lakhs was in check. The rest was by cash. The agreement bears the receipt. My lords, agreement bears the receipt. Yeah. Please see. Please, my lords, just see the agreement, my lords. This was referred to the forensic lab. It has come back as proven. Now, my lords, once the agreement signature is proven, please see the endorsement notes at 244 at the bottom, 10E, which has a receipt of 25 lakhs. At least the refund amount notes could have been considered by the courts. There is no embargo notes on making this payment by cash.
Many a times there are no traces of cash.
The trace notes, the best proof is the agreement and the receipt. Notes, can they unjustly enrich themselves? They make a bald denial.
The specific performance, so it's not a recovery of money.
I had an alternative prayer of
performance.
Lords, I realize on specific performance, I may be in difficulty.
No, I'm saying in the specific performance, should you set up an alternative prayer? And substantive prayer depends on the existence, validity, and all other aspects of the agreement.
Lords, that your lordships
is not so automatic.
Your lordships get that at 244. Your lordships get that.
What do you want us to see?
Lords, 244, the bottom. There are 2 sets of signatures there, Lords. One is 10B, which is one Mangilal Jain who represents D3. And then below that, Lords, there is a receipt for 25 lakhs, which is 10E. Now, this gets referred, Lords, to the forensic lab. And the report is at 537. These are treated, Lords, as admitted signatures.
What do you say about the car?
Yes,
absolutely nothing, Lords. Absolutely nothing. Nothing has been paid. Out of 2 crore and 10 lakhs, they say that 5 lakhs has been paid in check. Everything else, and he's.
What about the check? What is the proof that he produced with respect to the check?
The check is there, my lords. It's in the agreement.
Has it been encashed?
Yes, it's encashed there.
Have you filed the proof?
No, there were some lapse there, but they don't.
Nothing has been filed.
They don't.
He says he's not even a PAN or an income tax.
They don't dispute the encashment of the check, my lords. They say it was towards a bond.
It's not that kind of a case. Thank you. SLP this.
Lordships.
यूपी में रजिस्ट्रेशन यहाँ पर नहीं करना चाहिए agreement of
Great. Yeah. Wait, please.
Item
22, Your Lordships. Your Lordship, last stand has been that he has to be a trained teacher. Your Lordship will have page 29, Your Lordships. The 4th clause, Your Lordships. He's not completed the training and he's asking for a scale of the trained teacher, Your Lordship. That's our consistent stand, Your Lordship. Nothing has been discovered.
You take it. Oh, 1 minute. later on absorbed, no?
Please, Your Lordships. So we asked if you complete the training 3 years and then we can pay him the scale. Nothing has been discussed by the LPA court, Your Lordships.
Both things, he's been working for such a long time. And teachers should be paid well.
Your Lordship, subject to completion of the training.
You have never taken him away from job.
No.
So it's been working for you day and night.
Please,
After so much time have passed, you say you are not fully trained and want to, you're not given the scale. Not a case. SLP dismissed.
Your Lordship,
Delay of 209 days also.
Some relief, Your Lordship.
Dismissed and delay. You want us to condone the delay?
Please, Your Lordship.
Delay condone specially petition.
So that I'm on a limited ground, the award, main award.
An arbitral award.
Yes, Milord. What has been agreed between me and the department is only with regard to the royalty in the event of the experiment being successful and the production being made. Whereas it is a commercially not viable, the technology is provided by them. I am allocated with a huge demand.
But isn't this an interim order?
It's an interim order, today your lordships are aware in the state, we are hand to mouth, and it puts on a huge cash crunch problem. And I will give some security, my lord, absolutely no issue. The reason is, my lord, on day to day, finding a cash is very difficult for an enterprise of this nature.
One more thing, Mr. Kodan, we could have normally given, but what is this you have said, para 3? I also marked that.
So far as
it is also agreed by learned counsel for the parties that the deposited amount is.
I have no control over what the order is written. I would
Unless you say the way to get out of such thing is you must state in the petition that this observation is wrong. Have you said that?
Well, the limitations of lawyer, your lordships are aware. I would not venture into make such.
Say out for an.
I would not make such these things. Your lordship. Only I will give security.
Stuck only by this portion.
I will give security, my lord, no issue.
Otherwise, we would have issued notice.
I would give the bank guarantee security.
Then you should go back to the High Court.
Your lordship may remind it back, my lord. I'll take chance there and there. Because today we are running on a hand to mouth, and then almost about 150 people jobs are at stake.
Senior counsel appearing on behalf of the petitioner seeks to withdraw the special petition to approach the High Court for filing a review petition by offering for seeking modification of the order. Permission granted, special petition is
Item 24.
Lordship Bill 24, the grants were permanently non-aided on permanently non-aid basis in Lordship, I'll show 2-3 pages, page 15 if Lordship can come. The college exists, the division of science in the college came in 2009 and the state's policy before 2001 we are giving grants. After 2001 we are not giving grants to certain subjects.
To disperse salary, granting aid from the government, granting aid from in 2023. 6 years. And then the salary stopped.
You paid him
salary stopped.
Now you are
grant from the government stopped, not the salary. The salary, the management will have to pay the salary. Lordship, if this is allowed, all the similarly placed employees will come.
But 17th March 2016 is what the High Court is relying on under the basis of the GO. Then 100% granted aid to respondent excluding.
So that is before 2001. The college.
Point is, at no point of time computer science was included.
Yes.
Why did you give that such vague instructions?
Lordship,
why did you exclude computer science?
Lordship, that was a policy decision that
why?
On specifically why it was
because computer science is something which is commercial.
Lordship, this is the first GREs of 1991.
17.3. उसमें बोला
Page 23 clearly mentions.
Just come to P4. Where does it exclude computer science?
Page
P4. P4 is the government order.
17th March.
17th March. This is regarding sanction of grant under scheme of
Grant, it is subject to the following.
It does not include.
इसका कहना है बाद में किसी का issue notice देगा.
Lordship, 39 days delay.
Notice.
Should delay condition.
But include.
Grateful. My Lord, in item 25, it's not about this one gentleman with respect. What the High Court and KSAT have not noted, if my Lord comes to page 28.
He was given the independence.
Yeah, my Lord will come to page 28. There are 883 people. What has happened with respect, my Lord, is that the matter from Nagaraj onward, because the promotion lists were never finalized.
They are posting again. How can they be given? Promotion. He was given independent charge on 3.
Everybody was given, 883 people were given.
Actual promotion took place in 18.
My Lord, actual promotion actually eventually takes place in 31/1/22. That's the current notification. That's the notification that is agreed by. That's page 28, which I'm asking my Lord to see. Before I read that, what I'm saying is, my Lord,
service or superannuated?
They had all superannuated. 31/1/2022 is to give them all pensionary benefits. Post-retirement, they are getting that promotion by way of this notification. Everybody's promotions, all 883 promotions were held up.
Saying that 3924 to 39/2009
yes,
is not a substantive appointment. That's your
no, my Lord. It could not have been because matters were pending in the Supreme Court.
Argument.
That is my argument. And my Lord will see even in the notification we say this. Effectively, what happens is
when you don't have a substantive appointment, where is it so? What kind? How long did you continue him as an independent charge?
My Lord, everybody, all 883 continue effectively almost till retirement. Page 28, my Lord will come. It's not just him.
When did they retire?
My Lord, he has retired in 2019, I think. The list is there. He's on page 37.
Superannuated in 19.
Yes, my Lord.
full service from him.
My lord, he has been paid. To be fair, his payment according to us and the stated position I will show if my lord wants to see that. In terms of allowance, he has been paid a higher amount.
He has never been promoted to executive engineer.
My lord, he is according to us promoted on 31/1/20.
Promoted the duty of executive in July 18.
Yes, but then that
2009.
There are orders even after that. My lord, there's this matter called Pavitra. What happens is Nagaraj goes into Pavitra 1, goes into Pavitra 2. And nobody's appointments, it's not just him. That with respect is what the High Court and the KSAT have failed to note. It's not just this learned gentleman. Everybody on this list has exactly the same problem. Our promotion list could not be finalized.
Are there more number of matters like this?
My lord, this 883 people in this very notification. My lord sees is on page 37.
All right, notice.
I'm obliged. My lord would be kind enough to stay or not precipitate in terms of I have to pay, otherwise there's a 30-day time, there's a 3-week time limit. My lord will see.
This is the judgment of the High Court. What happened during the pendency?
My lord, it says at page 7, my lord will come to the impugned order.
Their case, original application was allowed by the tribunal in 23, your writ petition is dismissed. But have you complied with the tribunal's judgment?
No, my lord, that's what I'm pointing out. Page 7, there's a compliance. I'm pointing out what the High Court has said, then I'm in my lord's hands. Page 7 of the impugned order. My lord may only say that this will not apply. Just this last paragraph. The order of the tribunal shall be implemented and arrears shall be dispersed within an outer limit of 3 months. I have come here.
For stay only, what else are you asking?
That is what, my lord. That is my difficulty.
Till the next date of hearing.
Yes, my lord. He's getting his pension in the meantime.
In the meanwhile, petitioner shall take trustee notice.
Obliged.
In the meantime. Trustee in addition stay till the next date of hearing.
Deeply obliged.
Yes. Let's please see at page 49. What has happened here is minutes. High Court, while issuing notice of motion in the made matter, has all issued notice regarding stay as well, minutes. In subsequent order, it was first time reflected in the order dated 19th of April that the interim order to continue. Immediately thereafter, I moved the clarification application.
Virtually a stay. And he says that executing court shall not. It's a stay order.
Minutes, please see at page 49 minutes. It was a notice.
Clarification, clarified.
Minutes, nothing was clarified. May see at page 49 minutes.
We are giving clarity to you. It's virtually a stay.
Minutes, the High Court has directed the executing court to fix the date beyond the date only for till the next date.
That's not the way High Court should do. We agree with you. They should not do it. They should grant. That's why interim orders must be very clear.
Please, minutes.
They can't be. But it's a euphemism to say that the executing court shall not proceed.
Minutes, now the difficulty is the matter is at the payment stage, Malaks. The objections have already been dismissed, minutes.
If there is an award, arbitral award, 34 is dismissed.
Please, minutes. Their objections are also dismissed, minutes.
Did they get a stay pending disposal of 34 petition?
No, minutes.
What is the date of the award?
Minutes, the award date is
June 16.
June 16, minutes.
And 34 to June 17.
Please, minutes.
Until 24, why did you not execute it?
Minutes, we filed the execution, they moved their objections, their objections were also dismissed.
So there was obviously a stay.
Minutes, their objections are also dismissed, minutes.
What we are saying is, award is 2017.
Please, minutes.
34 is dismissed in 2022.
2020.
Obviously, there must have been a stay in between, or else you would have executed. 5 years have passed there.
Please, minutes.
And now this 34 is dismissed in 24 within 2 years. Okay.
Well, it's already been 2.5 years.
If you interfere with the order passed by the High Court, we request the High Court to take up and dispose of the Section 37 application as expeditiously as possible. That will serve your purpose.
Stay application decided.
This will help you.
Please, please.
So better, this much better than Reissuing notice and staying.
May I please your lordships? Lords, I draw your lordships' attention to page number 25, my lords.
Yes.
Lords, page number 25 starts at page 24. My lords, the subject is site inspection report regarding correction of settlement Bandhuma's error. Now, your lordship may kindly have a look at page 25, my lords. My lords, third line. Due to which there is a settlement error in the land of the non-applicant, which should be rectified, and 0.2 hectare out of Khasra number 379, area 0.35 hectare should be registered in the name of the non-applicant, Willows, that's the respondent, and 0.10 hectare out of 0.35 hectare of Khasra number 379 should be registered in the name of, Willows, there is a typo error here, in the name of the applicant. Willows, this is a translation copy. Now, Willows, may I draw it?
It's all facts concurrent. All the three courts have held against.
Willows, may kindly give me.
Interfere in this.
Willows, may I just. Willows, may I? Willows, this on this point, Willows, this has been reaffirmed in the Panchanama. Willows, on the question of law, I draw your lordship's attention to page 66, Willows. Kindly, Willows. Willows, para 6.
What question of law?
Milords, this refers to section 257 of the Madhya Pradesh Land Revenue Code, 1959, Milords. Milords, may kindly see, we had raised this question. The appeal has been filed by the defendant on the following grounds: that legally the said suit was related to section 257 of the Madhya Pradesh Revenue Code because the Tehsildar had passed an order under section 89 to transfer 0.25 hectare out of 0.35 hectare of land from Khasra number 379 in the name of respondent Rajau. That is, Milords.
According to you, the suit was barred before the civil court.
Milords, yes, please, Milords. Milords, now your lordship may see the impugned order. Milords, may see the.
Nowhere you argued.
Milords.
You have not argued that anywhere.
Milords, this is.
Did you just show us your second appeal grounds that the suit is barred? When did you ever raise the plea that the suit is barred?
Milords, this plea is, which I am reading out to your lordship. Milords, this is in the first appeal itself. I had raised it, Milords. Milords, unfortunately, I have not.
See the issues which have been framed at page 44. None of the issue relates to the jurisdiction of the civil court.
I am very obliged, Milords. Milords, there should have been two issues. Milords, one issue regarding the application of section 257. Milords, kindly. Milords, give me only a minute, Milords.
Not at this.
Milords, this person is now suffering where his 0.10 hectare of land has been taken over by.
This was argued all through, no? Thank you. Not a case.
Okay, Milords.
Self-decision.
May I please, my lords? That this is a matter relating to appointment of Milord's BT assistants or school teachers for classes 6 to 8. Lord, this issue relates to Milord wrong key answers published by the Teachers Recruitment Board. Lord, but the issue was not at all gone into by the Honorable High Court, Milords, in the order of the Lord, if your lordships will kindly take Milord's P4, page 58. Your lordships will see how many questions they have changed the key answers.
It's all, no exam gets completed in this time.
Lord, if your lordships will see the three questions which I am raising, they are found, Lords, at page 59 and 61. Lord, your lordships will see the number of objections raised.
Fortunately, the law is very stringent with respect to what's.
Yes, Lords, I respectfully follow that. If your lordship kindly takes page 35, they have themselves mentioned, my lords, the syllabus to be followed. Lord, in an ordinary case, my lords, I do understand, Lord, that the judicial review is very limited. But at page 35, Lord, they specifically say that the syllabus for these examinations is to be taken from Gazette number 122, which specifically mentions the books. And from those very books.
Thank you, ma'am. We are not interfering in this. SLP dismissed. Next.
Item 29.
Please, Your Lordship, I pay for the petitioner.
Similar matter.
Similar matter, Your Lordship.
Notice.
Tag in the obliged.
This tag.
My lord, in this case, my lord, a plaintiff filed a suit, my lord, under Commercial Code Act for the transaction of 2018 and 19. My lord, the suit was filed in 2021 after framing of the issues. They filed an IA number 4 for placing an additional documents on record. Now, these IA, my lord, was consisting of two categories of document. First category was, my lord, where the photocopy were part of the record of the plaintiff, and second category, my lord, where the photocopy was not part of the record. Now, court rejected the application and partly allowed the application. Again, my lord, when the evidence was led, after 1 year, they filed an IA number 6.
Additional documents to be filed.
But my lord, it's contrary to my lord. But my lord, it will, if it is allowed, my lord, then there will be no end to.
All your contentions are kept open. 1 or 2 documents additional.
No, it's not 1 and 2. They are the entire invoices.
High Court permits, High Court has affirmed it. So we are not.
My lord, we kindly see, if this is allowed, my lord, there will be no finalities in abusing the process of law. One party is, kindly see, my lord, may I just show, my lord, kindly see.
If we interfere, there will be no finality to the High Court's order.
No, my lord, but it's not required. It's completely contrary to law. Kindly see, my lord, kindly see page number 79, my lord.
We are not inclined.
My lord, may kindly see.
My lord, the High Court in view of the fact that it is interim in nature.
No, but my lord, kindly see. My lord, may I just be given, my lord, 20 seconds. Kindly see, my lord, just page number 79. Kindly see, my lord. It's a trial court order. It's pointing out the reason. IA number 4 had been filed under Order 11 Rule 4 seeking permission to produce as many as 11 documents. Among them, originals of the office copies of the invoice sought to be produced now was found at serial number 6 of the said IA. The defendant had rejected IA number 4, objected IA number 4 by filing detailed objection. Having heard both sides, the court on so and so passed an order allowed IA number 4 in part.
2021 suit, if you don't keep on objecting, matter would have been over now. You just
his application has been, my lord, his application has been rejected. He did not file an appeal. He did not file any revision, my lord.
Thank you.
He filing subsequent application, my lord. Completely contrary to, my lord.
But the petitioner, especially petition is missed. 31.
Item 31.
In this matter, my lord, the both the respondents has demolished it so far as the case is concerned, and it was sub judice before the municipal court, my lord.
They are only complying with the Supreme Court's direction to give possession, right? Isn't it? Supreme Court's order is directing issuing possession. So they are bound to do that.
But it was pending before the municipal
Supreme Court's judgment, our own judgment. So who can, they are implementing it, that's all. 13th April 2019 order, specifically Supreme Court said restore possession. But the way the possession was taken by you was completely illegal, what the court found. So it directed taking possession of the property.
No.
Restoration of possession.
The matter was before the municipal court where I have a right to raise questions, my lord, so far as the property and possession was concerned.
Possession.
There are 3 things, my lord. One thing, no notice was issued in this, my lord. Firstly.
Notice was issued?
No notice was issued.
Which one?
Yes, my lord. This is ex parte.
What kind of litigation is this?
Now, secondly.
At least to spare the Supreme Court from this.
No, secondly, this 31/5/2000.
Unending litigation is.
No, 31st of May 2024, which is the basis of the order, my lord, that has been stayed. So I want to bring that the order on the record, my lord. Not to make kindly have this order, my lord. That order has been stayed. So base order has been stayed, my lord.
Supreme Court, this court.
Yes, no, not this High Court. The base order of the trial court by which the documents were taken on record, my lord. A writ was filed and in which this order has been stayed, Lord. At page 3, Lordship would see, my lord, the trial court with the order dated 31st of May 24 allowed the application filed by the plaintiff under Order 7 Rule 14 as well as Section 65 of CPC. So, in my considered opinion, the trial court has committed error in putting the affidavit filed by the plaintiff in party. This order, not now, it has been stayed.
Show us good mark.
Yes.
Yeah. So then what do you want to do? You want to, if that is stayed, then what is to be done?
Because these two orders are subsequent orders.
How does it make any difference? What do you want? You want to withdraw the special petition?
No, because these orders still carry, my lord. The High Court order is still there, my lord. So,
additional document,
sir, the reason is,
some additional documents.
Lord, if the notice were issued, I would have pointed this out before the court. High Court itself, Lord. High Court didn't even issue notice, my lord. No, Lord, High Court didn't even issue notice. Lordship may kindly appreciate, Lord. At least let me place this on.
Documents to be brought on record.
No, these are very material, my lord. What?
Subsequent?
No, this is
still pending.
My lord, it is at the rebuttal stage, my lord. Evidence, both the parties' evidence is closed, my lord. It is after the evidence is closed, my lord, that he, and that too, my lord, those photographs and everything, they are not admissible, my lord.
Thank you. This will be discussed. 23.
May please. My only limited plea is, my lords, I may be permitted to file my statement of defense. So 2018 termination before the DIA seat comes up for the first time in 2023, my lords. I am set ex parte. I seek a recall. The court notice, the tribunal notices that I have not even been.
You are set ex parte even 1st of May 2000.
1st of May, yes, my lords. My recall application is filed on 30th of September. My recall is allowed. Please have page 379 for a moment.
September 24.
Yes, my lords. 30th September 24.
But despite that, again, you don't go
only for one hearing, my lords. Only for on one day. My lords,
it has been so indulgent with you.
My lords, because the court notices that I was not served in the first instance. Please have 379 for a moment.
You've been over.
Please have 379. Samsung, my lords, a small service provider.
From 34 or 37.
No, my lords.
No avenues.
No,
for 227. That's also doubtful.
Yeah, that's my your lordships have said, my lords, recently that in exceptional circumstances it can be granted. I'm only playing. I'm only playing this, my lords.
No.
Only there is only one witness. The cross examination.
Neither on the merits nor on forum as an exception.
There is just consider this, my lords. I'm not on the forum in merits.
But he didn't set you ex parte.
It was recalled. It was recalled. Please have 379. I was not served in the first place, my lords. Despite that, I am a small service provider, 2018 termination. Samsung comes with a delay of 5 years. I may at least be permitted to put in my statement of defense, my lords. Only pleading on equity, my lords.
Therefore, there is no case for
look at the contest, my lords. A small service provider versus a giant corporation. So, all
times anybody will give you
only once. That's my plea, my lords. Only once my opportunity has been given. 30th September, my opportunity. First time my opportunity is given. December it is closed, my lords. Kindly consider it on equity only.
Thank you.
Grateful, my lords. Most problem.
Please, Lords. Item 34. Lords, a short question, but a very important question is involved in this matter. Lords, whether the accused or the agency representing the accused or the main body under which it is working has the right to be heard at the stage of complaint. Lords, 340 application is basically a complaint. Whether a complaint, further investigation has to be carried out.
They are NIA.
NIA. My lords.
NIA, what is your plea that NIA should not be made a party?
Lords, this is a complaint case, Lords, where I am filing a lodgement of a complaint. 340, Lords, judge of this honorable court has said that at this whether a complaint has to be lodged before the magistrate, they will have a defense. Lords, before the magistrate, every party will have a defense. At the stage, it is, Lords, it is akin to if I go to police and the police ask the accused to be heard, Lords, defense at this stage cannot be there. 340, the ambit of section 340.
You've seen that that comparative.
Lords, at this stage, my lords, they do not have a right to be right of audience. Lords, at this stage, the court only has to see whether the case is fit for a complaint to be lodged.
There is an order of transfer of 9th of August 2022.
Lords,
transfer to NIA 9th of August.
That's correct, Lords. Lords, at that stage, 161 statements have been...
has directed these additional documents to be filed, and then
Lords,
the present application comes in.
Lords, I'll explain what happened
in preliminary inquiry.
Lords, I'll explain this, Lords. What happened is, it was with the police, the court, NIA court took cognizance, so it called upon the documents. At that stage, well, I examined them, I found discrepancies, major discrepancies in 161. And Lords, in such a case, 161 statements hold.
Who will defend? You are the petitioner. Then who do you expect others?
Lords, at this stage,
they're asking you, just asking. So who would contest against you is our...
Lords, I'll explain this. This is basically, court will just 340, 195, court will just see whether this complaint, this application is worthy of a complaint or not. That is on the ambit of that. Once it is takes this view that yes, this is worthy of a complaint, then the magistrate, then before the magistrate, every defense will be there. Lords, they are only pro forma parties. The court will only see prima facie take a view whether this application is worthy of a complaint or not. It is like I go to a police station, the police will just have to see.
Right, they might even, court might not even ask them.
Lords, but they cannot have it. Lords, it will be prejudiced.
There are too many things in this.
Lords, this is...
Court, where is the question of a court consulting or asking them to oppose your application? Court will take a call on its own.
Lords, court can always take that call, but Lords, the
ambit of 340 there anywhere near around you.
Lords, it will seriously prejudice my case.
Of course, that's what we are saying.
Lords,
you unnecessarily you are assuming too many things.
Lords, they are the party which their officers are accused in this.
Take away the power or the jurisdiction of a court to take a decision as per law.
Lords, that is always there, but the ambit of 340 says that you do not have a right to be heard at this stage.
Misconceived.
Lords,
self-be dismissed.
Very well.
Misconceived.
Very well.
No need for you to be apprehended so much.
Lords, but the procedural bias would be there, Lords.
They are anyway there. It's once the transfer is there, their presence is already there.
Lords, very well. I'll leave it at that. Grateful, Lords.
Look, I'm in 35 for the petitioner. This is an issue where the NGT, my lords, the composition of the NGT is called into question.
What happened? Why did we adjourn it last time?
Because there was another connection, my lords. My lords may just see the Act section 4.4c and the proviso there too, my lords. Yeah, we have a the NGT. We'll hand over a copy.
What is it that we want to know?
Yes.
According to us, the statutory provision, if it is literally taken, it is completely impractical. Correct?
Yes.
To that extent, you also agree. So therefore, there's some kind of a modulation which has occurred in 2011 rules that have been formulated, where the rule says the minimum number is 1 judicial and 1 expert.
Right.
That's been working. What's
the
problem?
But the issue is this, my lord, just sees the proviso for a second. It says there has to be an equivalence in the proviso. No, my lord, just see the Act, because the rules, my lord, have to be controlled by the Act. My lord may just see the... Yes, my lord may just see 4.4 subsection.
I want to know from you.
Yes. But our major
what's your problem?
But our major concern is this: we have challenged the CRZ regulations. Tomorrow, my lords, I don't want, whichever way the NGT passes an order, look, we don't want the challenge to come before this court saying the composition of the tribunal is not in accordance with statute. My lord may just see the provisos.
Why are you wasting your time on
because
if I may clarify, my lord,
yeah.
I am in item 35.2.
Yeah.
This issue has been dealt with by the Bombay High Court, my lord. There is a detailed judgment passed. An appeal against that is pending before your lords in a different matter. It's in this court, my lord.
Why
If
my,
my,
similar issues?
no, we don't want a tagging, my lord. If
Yes.
my laws may please take up my file, my lord, 35.2, and page 145 is the Bombay High Court judgment, where they've specifically referred to section 4 of the NGT Act and says equal composition of judicial and expert members is mandatory. And they also refer to an earlier Madras High Court judgment on the very same issue. Now, appeal was filed by the NGT itself against that before your lords, and notice was issued, and my lords were pleased only to state a different part of the impugned order. Thereby, this is the law as it stands today, the para 40 of the Bombay High Court.
Here, then it's pending here.
It's pending here. It's pending here. Now, our concern is not exactly the composition of the tribunal. We only don't want that to be a ground for them to challenge the final
have
judgment.
another meeting with someone. I'm just
Our
sitting
concern is that this is a critically time-sensitive issue. The CRZ 2019 makes drastic dilutions to the earlier CRZ notification. No development zone of 200 meters reduced to 50 meters. Our submission before the NGT is that this violates the principle of non-retrogression. Now, in Bombay, it's now being implemented. CZMPs have been prepared and soon development permissions will be issued. We only want an expeditious adjudication by the NGT. Now, they have implemented all the states, which is wholly unnecessary, my lord, in our submission. This implement will now only result in delaying the proceedings for a very long time.
Just to add to my lord friend, we've been in court in 2021, my lord, there was a jurisdictional challenge. It's only at the stage of final hearing that the order came.
Justice Venkat, you get so anxious.
Yes, because all of us. Whereas we have been in court since.
Your imagination of what future difficulties could arise has led you to so much of litigation that the whole purpose of having an expeditious hearing is lost. Nobody objected to the bench, number one. You were thinking that in future you will get a positive order and the Supreme Court will stay. Second is with respect to the implement of the other states. All that we can do is direct them to expeditiously hear and dispose it off. I mean, how can there be an objection? Suppose if it is a CRZ in state of Tamil Nadu, is Tamil Nadu state? The states. Those persons in Tamil Nadu are not stakeholders to it.
Respectfully,
to object to that, how can you make? They have the carriage of the proceedings. They will make parties. You might say that don't await service on them or don't give them much time for counter affidavit. Proceed with the matter. But then your whole thing is getting stayed unnecessarily. We will ask them to dispose it off as expeditiously as possible.
If my lord does that, then we agree. Yes. My lord.
While we are not inclined to interfere with the order passed by the National Green Tribunal, considering the importance of the issue, we request the tribunal to take up and dispose of the original application as expeditiously as possible.
In a time-bound
manner for.
Because, my lord, this would result in irreversible damage, my lord. Development permissions have been.
It's a central government notification. The union took 2 years to file their reply.
Stop now and go and contest that matter. Don't waste your time in unnecessary litigation.
Would my lord consider direction that the bench currently constituted may hear the matter to obviate any future.
Nothing like that. Thank you. Next.
Your Lordship, my lord record my submission at least on that point.
I'm sure. We'll direct if we.
Item 36. I'm so sorry.
My lords, I
It's
appear
Article
number 36, my lordship. My lordship, I appear on behalf of the Waqf Board, your lordship. Your lordship, I seek some accommodation, your lordship. There has been a reconstitution in this matter in the Waqf Board, and I had sought some instructions. I am yet to receive.
When is this from 2017?
Because
the impugned order is 2015 impugned order. After notice, it is pending.
Just one humble prayer, Milos. In morning, I mentioned this matter. This is the connected matter, and the connected matter, Milos. That is diary number 10542 of 18. I have been informed that my client has expired, Milos. So I need time to, Milos, at least bring the legal hires on record.
What's happened?
I beg to appear in item 36.
What is this? We see that there's Justice Simkirti Singh's order.
Yes, my lord.
Despite all that, some kind of a protection is given in all respects. But after notice matter 2615 onwards.
My lords, there have been, my lords, what has happened, I believe a lot of substitutions, etc. have happened in the middle.
What
My
is
lords,
there for us to?
My lords, there is. My lords, with great respect, if I may point out. My lords, the petitioner here is.
I think it got listed because of the reason that the Chief Justice has said old afternoon matters pending here for years together. List them. That's how it got listed from out of grave. They pulled it out. There's nothing in this now.
Yes,
my lord,
there is no coercive order as against them.
Nothing is there. I don't.
My lords, they are, my lord, completely interlopers. The tutu.
No, how can I be an interloper? I am a bona fide purchaser.
It is pending.
My lords, if I may.
Law is the impugned order.
My lords,
that kind of protection was given.
My lords,
preserving the property, lord.
2012 High Court judgment.
May I,
Yes,
my lords?
And before that, 1990
order.
My learned
1993 order affirmed by this court.
My lords, may I?
May I make a preliminary point, my lords?
My lords, my petition is my
He's
friends
already
don't mind.
Preliminary point, my lord, if I may.
No.
I got it.
No, for the respondent. You make the preliminary when we ask.
There's a technicality here, my lord.
What is the technicality?
Which is that the impugned order is a common order against 3 miscellaneous petitions. They only come in appeal against one.
All right.
The other stand confirmed. It's the same.
My lords,
the only difficulty as far as the second connected petition is concerned, the petitioner himself has expired now.
All right, sir. There's nothing remains in this SLP.
My lords, may I? My lords, may I? My lords, may just bear with me. My lords, there is something in this that I wish to point out.
What is it?
My lords, this is and my lords may just bear with me for 2 minutes because there are too many facts. I would just like to very crisply put it in 2 minutes.
One of the reasons why we should not be entertained.
May I, my lords? My lords, 1993 order basically talked about 2 things. My lords, first of all, who am I, my lords? I am a purchaser from a person who was holding 6 annas share as a mutwali in the Waqf deed. Now, my lords, may kindly bear with me over here. Something very relevant and very important, and I will show my lords how all these people on the other side are irrelevant for this particular case. Now, my lords would kindly see. There was a Waqf deed. In that Waqf deed, my lords, arbitrations took place. And my lords, way back in 1936, it was pointed out that there will be 2 mutwalis. One mutwali will take care of 10 annas share. The other one will take care of 6 annas share. Now, my lords, thereafter, this particular arbitration, etc., everything, my lords, reached a finality. In 1991, my lords, I was the person from whom I purchased. My lords, he was being evicted by the government in 1991. He went to the High Court. Now, my lords,
parties to work out their remedies in the meanwhile.
Court, my lords, said that this particular eviction, which is being sought to be effected by the government, is actually illegal. That portion was set aside. And my lords, a particular direction was passed. That direction was that there are suits pending. There is an injunction order with regard to, my lords, not selling off or not alienating.
Mr. Zakir, we are not sitting in there.
No, my lords, may I?
To suit for
Therefore, my lords,
suit for disposal. He has looked into all the matters.
My lords, my only grievance. My lords, my only grievance. My lords, my only grievance.
You want?
My lords, may I just place 2 facts and I'll leave it at that. Today, my lords, very, very importantly, and what has been missed by the Honorable High Court, my lords, with greatest respect. My lords, after 2004, the 10 annas, my lords, property holders, my lords, that chain has actually extinguished. Everything vested in with the other person. And my lords, the whole property.
Also, there are such.
My lords, the whole property.
There is not. There is.
We are very. No, don't interrupt. He is
My
already
lords,
having a lot of problem with us.
My lords, may I, my lords, therefore. My lords, this was a contempt petition.
That's right.
In a contempt petition, my lords, I having a degree in my favor, possession was granted to me. My lords, all that has been rendered redundant.
Very carefully, since you keep this.
My lords, there is
My lords,
At every stage, yes.
my lords, custodial ledges after that. That's expanding.
Also intact. He says
My lords,
overlap.
This is completely.
Why from 2015 there is no? Was there an interim order here?
No, my lords, there was no interim order. But my lords, may kindly bear.
2015 impugned order without an interim.
My lords,
giving rights to parties to work out their.
My lords, may I say this with great respect? Today, my lords, the petitioner who was there before the Honorable High Court is a person who doesn't belong to any of the family members. My lords, therefore, today, kindly appreciate this, my lords. I am a bona fide purchaser from the Mutwali of 6 annas share. My lords, I was put in possession by the court of competent jurisdiction. And my lords, thereafter, I have been dispossessed in a contempt jurisdiction.
But not dispossessed, my lord.
Custodial edges.
Not dis.
Although title suit number 488 of 1992 stood dismissed in default in 28/6/2002. My lords, once it was dismissed for default, it has not been restored.
I've heard you. SLP.
My lords,
Deep now. SLP. Thank you. Default. Not a case for. Next.
deeply aware.
36. This was 36.
My lord, in item 37, we are seeking a short accommodation, my lord. We are awaiting.
We will hear you. This is an important matter. The post practices.
That's similar issue is pending. I have prepared a chart of all the matters.
26 needs to be interpreted.
Yes.
We thought we were just looking for some judgment on this point. No, this is not
No
covered.
judgment because the issue is pending before this court.
Interesting question.
The batch of petitions from different states.
Goes along with that. Okay. Is it listed before some bench?
No, Lux, it's a regular matter. Right now it's not listed. Leave granted matter. Previously it was listed.
Goes along with civil appeal number 7123 of 2021. We thought of listing it at 2 o'clock and we thought of listing it at 2 o'clock and disposing of. But if similar matters are pending, we won't do that.
Yes.
Post along.
Grateful.
Can be heard.
Yes, my lord. Last time Milord had directed the other side, Milord, to look for some Milord accommodation, Milord.
Have you found out?
My lord, I am for respondent number 11.
Who is the other for the government? Which state is this? State of Bihar. State of Bihar. Accommodate them. Accommodate both of them. Both of them have put in almost 10 years of service. Now you're working, right?
No,
I am working, Milord.
How could you?
Milordly, I am working, Milord.
Granted a stay.
No, there is no stay, Milordly. I have filed my additional.
Lost before single judge.
Yes, Milord. Milord, that is what I am trying. I am working, Milord. I am putting my attendance. I do not know the reason, Milord, because but I have already filed
any salary since when?
No, I am not really getting a salary.
Not working.
I wanted to make some submissions, my lord.
There is a state.
I'll take instructions. My lord, there is. My lord, please allow me to make some submissions.
1 minute, we'll hear you.
Try to.
See, both of them, this petitioner from 2009 to 2018.
Please, Your Lordship.
So far as the respondent is concerned, worked from 2005 to 2009 and thereafter 18 till date is what we are assuming.
Yes.
He asserts that he's been in his country.
Yes.
We don't agree with that.
Yes.
But you find out. You have adjourned it for more than once. I said, why should we adjourn it further? Find out and properly tell us.
Your Lordship, let me 2 weeks after Holi, Your Lordship. My lords.
To make some submissions.
It is evident from the court that the petitioner herein worked
both of the posts. You didn't say last time.
After he was appointed,
he's been removed
from 17/3/2009 to 14/8/2018.
He made a wrong submission last time.
Whereas the respondent, number 11, worked from 14th of May 2005 to 16th of May 2009 initially, and thereafter from 14th of August 2018 onwards. It's also not clear as to who is presently working.
But look,
the director of state government to file an affidavit indicating the present position with respect to the employment position of the petitioner as well as respondent number 18.
My lord, I have the information regarding.
Tell us.
He is working. Last occasion, he made the statement that he's been removed. He's not been removed. He's still working. I have it on.
He's working.
He's working.
1 minute. He's working since when?
He's working since 2009.
2009.
2009. And last occasion,
so then
statement was made.
After 2009, then when he lost before the
My lord, he lost before all the 4 courts, but despite reason best known to the state.
Working, then we will rather. Then you have never worked at all. Then.
Pardon?
You have never worked at all.
I worked initially, my lord, and after that, just on the base.
What was the period during which you worked?
4 years.
From 2005 to 2009.
Yes.
You are right. From 2005 to 2009. He worked substantially then.
Yes.
You'll have to allow his case.
So, my lord, the real issue involved here is illegal appointment. All the 4 courts have held that his appointment is.
2009 से भी काम कर रहा है. Okay, उसका 17/3/2009 to 14/8/2000. हाँ. More than 12 years. How can we remove him?
My lord, he's got to make one.
We are trying to see both of you can be accommodated. Take instructions.
But my lords, on merit, my lords, I wanted to make some submission that it is illegal appointment, my lord, to start with.
Shiksha Mitras.
Shiksha Mitra also, my lord, certain material facts are suppressed from the single judge.
All right. This after 2 weeks at the adjourned by 2 weeks at the Learned Council by the State of Bihar, taking instructions, accommodating the petitioner as well as the respondent number 1 in view of the fact that both the persons have worked for some time. List after 3 weeks. Yes. Find out and come. Grateful.
This matter had come up on the last day when your lordships had asked the respondent that the list of those people who were the 20 to 22 batch, that should be produced, the merit list. As per your lordships.
We are 20.
One after another is please. Everybody don't talk to them.
Yes. So there are a number of applicants. I will give the particulars about all of them. And let me just introduce what my case is. And then I'll tell your lordships, my lord, how actually the whole issue can be concluded because there are more than 2,000 vacancies. And the number of people.
The only question which will arise, even if we assume, if we can conclude that the interpretation of the rule by the High Court is not correct, then the question of, as Mr. Gupta was saying last time, that the select list has expired. Perhaps that's it.
It's not. There are 9,000 people appointed. My learned friend was appearing, and in spite of the fact they are appointed, he was opposing relief to us. So, my lord, I am going to show the rule to your lordships today and say that even their appointment, therefore, cannot sustain.
Hold the rule in your favor.
Yes, it is.
So how can relief follow? Because in the meanwhile,
we have already been declared eligible.
2022.
We have already been declared eligible. We have already participated. Only our result is not being. Let me just give your lordships a few facts. We are people, my lord, who did this diploma, 2-year course.
You get the point. When that's
Yes.
seen.
We have participated.
Select list part of it, there's a problem.
Yes. Now, even the rule. Now, I'll tell you, Lord. Last time, my Lord Justice MISRA had said that is there a power to relax under? That's your Lordship had asked. Now the rules are on the record. I'm going to show it just now. But please see the rule with me. At page 5, the rule is there. Kindly see rule 6.1 and 6.2. High Court is not right in interpreting the rule.
We agree with you. Prima facie, we agree.
Yes, the rule doesn't want
the rule is not intended to say that you should have got the qualification by that time.
Correct.
It is intended to say that this is the qualification which should be
correct. The NC.
When it should be, in fact, in every recruitment process.
Correct. Now see the advertisement.
Time the interview takes place, by which time you will, because JEE and all other examinations
yes.
pass through the graduation.
We had got it.
You get
now,
certificates
now
and
what is our case? We got selected in 2020 in the diploma course, 2-year course. We would have qualified by June 2022. Because the board was not in position, our training was certified to be complete in June 2022.
What was said last time.
We can't interpret. I know.
Wait for qualification. You are on this side.
No, I'm going to tread on his toes in a bit.
Yes.
That's so a group of people, Malas,
wait.
Has been referred to court number 2, Malas. We need to be protected, Malas. Same advertisement.
No.
What court number?
Who are the
No, this has been going on for a while. They've been trying to step on everybody's toes.
Yes. Malord, I have a suggestion to make in this one.
Tell us, because
I have a
part of it we will of course.
Your Lordship may hear me. I will cover everything. And
Prima facie on rule interpretation, perhaps we are with you. We have heard them, we hear them.
So,
second question arises as to you, pursuant to the amendment in the notification, you appeared and you perhaps were.
No amendment.
What happened after that?
I'll just.
What happened after that?
Yes, only 2 minutes. We are students who got admitted in June 2020. We should have completed the diploma in June 2022. That completion of diploma means 2 years training and examination of the first year and the second year. 2 years training completion certificate is given to us on at page 147 in June 2022 itself. Since our examinations are not being held, in August 2020 we filed a writ in the High Court in 22 for a mandamus saying, please hold the examination. When the writ is pending, the first year examination is held in September. On 29th September, the result of that examination is declared. The writ comes up for hearing on 29th September. On 29th September, the High Court passes an order.
Single judge passed the order.
At 217 saying that they should be also considered in this process. On 29th September itself, the board publishes the first notification. First notification specifically includes us as participating. Thus, the second notification is published on 21st October. The second notification also includes, these 2 notifications are there at page 219 and 222. The second notification also, yes, 219 and 221. Second notification also includes us.
Yes.
These notifications, the order of the single judge is then taken up in appeal.
Division bench says that's virtually a cutoff, so you can't have it.
Yes, the division bench says you should have got it on the date of the advertisement. Now, the board does not, the board files an affidavit completely in our favor, which affidavit is reproduced by the division bench at page 12 onwards. And the board accepts at page 13. I want to read 2 paragraphs at page 13, para D and E. Please read those 2 paragraphs. The board says, we are at fault. Yes. Now, subsequently, what happens when this judgment is reversed by the division bench? We come here. By that time, we have already participated in the selection process. Interviews are also over. Our second year result came on 30th December. So on 30th December, all results were out. Interviews are conducted after 30th December.
December 22, right?
Correct. So interviews are subsequent to 30th December. So, one minute. So, yes. So when we came and filed this SLP, your lordships in the first instance passed an order, no merit is to be declared till this SLP is decided. That order is the first order of 28 July 2023.
Is it this bench's order? No,
no, it is an earlier bench. 28 July 2023. 28 July. Until further orders, para 8 of this order, on the day when notice is issued, until further orders, the West Bengal board. 1 minute. Got the order? Let's have the order. 28th July, the very first order in this SLP. That will be the very initial order.
28th July, connected, right?
It says, until further orders, the respondent West Bengal Board of Primary Education, last para I am reading, is restrained from declaring the merit list.
Oh.
Then what happens? The board comes. The board says, sir, now just see the 29th January.
Is that varied subsequently?
Yes. On 29 January, that order is varied because the board says we have 11,000 vacancies. The number of candidates just see.
Completion show 22nd, then 29th.
All right. Your lordship may then first have 22nd January order. 22nd January.
They find an affidavit in
correct.
The first interim order, as you were saying, is
28th July. This is modified or there is another order, this will be modified later on 22nd January.
24.
Yes. Correct. In the first instance.
Yes, we got it.
My Lord Justice Mishra's got it.
Yes. That was heard a number of times by the bench of Justice Imakoli.
Yes, my Lord, yes. In the first instance, the respondent West Bengal Board of Primary Education is directed to file an affidavit furnishing inter alia the details of the number of vacancies that were advertised for the subject post, the number of candidates who had applied in response to the advertisement, and the number of petitioners who have approached this court for appointment on the plea that they are qualified from the 2022 D.El.Ed course. Detail of candidates who qualify for appointment and those who do not qualify as per board, and reasons therefore shall be furnished.
Okay, we call for give details.
So a detailed affidavit was filed. Now what that affidavit says is recorded in the 29th January order. Please have that.
29th January. Yes.
While order dated 22nd January 2024, the respondent West Bengal Board of Primary Education was directed to file an affidavit furnishing certain details relating to candidates. The said affidavit has been filed with copies furnished to learned counsel for the other parties. As per the affidavit, 11,758 posts in various subjects, in various categories in all districts across the state of West Bengal were advertised for the post of assistant teacher for primary classes. After furnishing the detail of the number of candidates who had applied in response to the advertisement, it has been averred, as per draft list prepared, 9533 qualified. So apart from us, under the blue sky, whoever was eligible, 9533 qualified. Why I am
includes you also?
No, does not include us. We have been kept out of this. We will come after the second paragraph. So these are all pre-2020 candidates who were. Why I am saying, emphasizing this, there are some impediments which I'll come to later and explain those. Now it is stated that a total of. I'll read that line again. As per the.
Are we here in the final hearing?
Yes, I'm ready.
We are here in the final hearing.
Yes. Okay. Yes. As per draft list prepared by the respondents, 9533 candidates qualified, which includes an additional panel of 5% candidates in accordance with the rules.
So total 11758 is the total number of posts. 9353 was qualified.
Only qualified.
Qualified?
Yes. Now it is stated that a total of 2108 D.El.Ed candidates have been found to be not qualified amongst the pre-2020 batch. Now that's not us. That's me. These are two different kinds of candidates who are NIOS qualified and people who were found not qualified as per the board.
No, that's not.
let's not say no so quickly.
No, I know what
Yes, it is. So this is not qualified amongst the pre-2020 batch. Now, it is further stated, and so far as these SLPs are concerned, the petitioners before your lordships are only people like us. There is no other candidate who is a petitioner. They have all applied for intervention.
All of you have applied pursuant to the 29th September 2022 advertisement.
Correct. We are,
as far as you are concerned.
yeah, there is no other petitioner.
Your case is the one which the division bench is talking about.
There is the SLPs.
Where the qualifications which they have interpreted the rule to say that you should have actually passed the examination by the date of a cut-off date of 29/9/2020, which is only the interpretation.
So there, and what I am highlighting, there is no other SLP petitioner. It is only people like us. Everybody else is an intervener or a respondent. Respondents in the SLP are fully satisfied. All qualified have been appointed.
One more clarification.
Yes.
If it is merely the 2022 September advertisement that we are talking about, where is the question of pre-2022 and all that? What kind of a data is?
No, my lord, those are people who were qualified.
Giving that data, it should have been simply that the number of posts that were vacant as on the date when the advertisement was issued.
Pre-2020 means those who were qualified prior to our batch, because there were other batches prior to our batch.
Qualified for the advertisement.
Yes, for the advertisement.
For D.El.Ed.
For the advertisement.
Mr. Patolia's batch of D.El.Ed.
But I don't need my friend's assistance to explain my case. So please take your seat.
I'm sorry.
Wait a minute.
Yes.
Don't interrupt.
Yes.
We'll come back.
I haven't interrupted. That's the reason why I'm doing.
Just wait for 2 minutes after him.
No, if your lordship will take your final hearing, I need to tell you something.
No, wait.
I'm not.
Wait, please.
Very well.
Just 2 minutes after.
Yeah, very.
You'll come immediately next.
Yes, sir.
Yes. And my friend is not a petitioner. He cannot be representing any petitioner. There are no petitioners.
I agree.
Yes. Now just let me complete the reading of this order. It is further stated that D.El.Ed candidates from 20 to 2022 batch have not been considered in the draft list due to issues pending in the present matter. Having regard to the fact that as against 11,758 posts in different subjects in various categories, in all, the respondents have found only 9,533 eligible candidates, including the additional panel of 5%. It is deemed appropriate to permit the respondents to declare the merit list with a rider that it should be stated in clear terms that the appointments made shall be subject to outcome of the present petition. And leave it to the board to do what it has to do.
Our decision on the basis of interpretation of the rule.
Correct.
But vacancies board is the one who is actually has the right.
And all appointments made so far are subject to your lordship's order.
The question that arises is on the basis of whether
we are qualified or not.
Considered on the basis of the 29/9/2022 advertisement.
Correct. That's all. That's the long and short of it.
Not get into this.
Correct.
Of the vacancies.
Correct. Now,
rest of it. In fact, we'll be careful not to tread on anybody else's.
No, there are
even the power of the board.
there are two other streams whom I must now identify here. One is a stream of people who have qualified this diploma from NIOS. Some
is that considered by the included order?
Just no. So what happened? So what has happened there is these NIOS people were declared ineligible. They went to a high.
I think that came before some other day.
Except, just let me tell you a lot. Complete this narration because how they are completely irrelevant to this controversy. So
you are not sent it back to the court, my lord, because there was a variation.
That's correct. So, my lord, these NIOS people, they filed their independent writ petition challenging the action of the board in declaring them ineligible. That writ petition got dismissed by the single bench. They then went into an intra-court appeal. Their letters patent appeal also got dismissed by the division bench. They have filed some SLP. We are not really concerned. Whatever may happen in that SLP, they have nothing to do here. This is one stream of people who want to get implemented. The other stream of people who want to get impleaded are people whom the board has found ineligible amongst the original 11,000. They are also now coming and saying, we have a problem. Now, this is true. Now, one last thing I want to tell your lordships. Just see this IA which we had filed, where the 2016 rules have been placed on record. Just have a glance at the rule. Since your lordship is hearing it finally, just have a glance at the rule. Because my lord had said that, is there a relaxation power? I just want to point those two rules to your lordships. The current rule 6 is as per, is at page 17. Please have that current rule. Please have a page, kindly have page 5. Just 1 minute. Have you got the IA number? Please give me, please have page 5 of the paper book. Your lordships, this. Have you got the IA?
We have 6-2.
ये जो रूल लगाया है ये IA.
No, he wants to show something which is power of relaxation.
Please give the IA.
No, maybe it isn't the. Is it an annexure?
This can go.
It's performance power.
That is additional point. And also,
of your lordship's paper book. Then I'll take your lord, because the rule has slightly been amended. Amended rule is here at page 5. Just I want to just make a point and then leave it for your lordships to consider. Just see page 5.
Page 5 of?
The paper book, your lordship's main paper book.
In the include order?
Yeah, that's right. That's right.
It's 5, page 5.
Yes.
The rule 6 is quoted. Yes. No person shall be appointed by the council as a teacher unless he is a citizen of India and has completed age of 18 years as on the first day of January of the year of the advertisement and has not completed age of 40 years as on first day of January on the year of the advertisement. So what is required on a particular cutoff date, the rule itself says 6.1. Now what is 6.2 which has been interpreted? And according to me, my lord, the view is not correct. Is the candidate shall possess the minimum educational and training qualification as prescribed by the NCT on the date of advertisement.
It's a prescription of.
Correct. Absolutely right.
Very clear.
Absolutely right. And what the NCT prescription.
Not intending to lay down a cutoff date.
Absolutely right. And now see the advertisement at page 219. Just see that also now only, so that your lordship just has that. Page 219. The advertisement clear.
Much turns on the stand of board.
Now see the stand of the board. The stand of the board is reflected. The board is.
Then that's a part of the advertisement.
Correct. Page 7.
The issue is whether the advertisement is contrary to the rule or not.
Correct.
You never committed any mistake.
No, 29th September is the advertisement. That includes us. Now please see the stand of the board before the division bench. The board says we created the mistake. That is page 12 onwards. And now before this court, your lordship may only note in the written statement they have conceded. They have said that if they are eligible, just your lordship may see written statement page 15. They say if this court finds merit in the argument, then please permit them to be considered in the recruitment process. That's the board stand.
Yes. You want to
My lord,
after
I am not
hear Mr. Gopal Singh.
adding just very small things.
After him we'll hear Gopal Singh.
Yeah. My lords, my submission is only this much, that all the appointments that have been made before this court are subject to the outcome of the present matter. So even those people who have been appointed are subject to outcome, number one. Number two, we are about 916 odd.
Okay.
Our merit has not been disclosed. That merit is what my lords have required, my lords. So those of us who will be in the order of merit as per the selection will come to this court.
You are not getting into numbers.
No, my lords, I'm not on numbers. I am only in terms of all appointments.
The decision of the High Court, that's all.
My lords,
And there is no other petitioner. These are all applicants, interveners here.
my lords,
Who's
that is basically to answer the applicants. So our merit is going to be what is my lords will determine. We are the
You both are for the present specially petition.
We are for the present specially petitioners before the High Court, against whose order we are before my lords. My lords, all three of us.
And as a matter of fact, your lordship can record 9,000 and odd people who are the pre-2020 batch. They have already been appointed, and their appointment is subject to whatever your lordships will ultimately decide.
Exactly.
But they need not be disturbed even if we are to be accommodated, because more than 2,000 vacancies are already there. And I am told that only about 1,900 of us have qualified.
Before the single judge will not be
You are saying that more than 9,000 have been appointed.
9,000?
Figures are, my lord.
Mr. Jaideep can give, my lord.
I'll give you a lordship.
9,000, I'll come back to you in a minute. In a minute, we have to hear you mainly, more than anybody.
Kindly hear us also, because we are the appellants before the High Court and we
Why will we not hear you? Why are you name?
Even before the learned single judge, below the stand of the board, below, I just read those 4 lines. It has further been stated on instructions by Mr. Saikat Banerjee for the board, learned advocate for the board, that debt qualified candidates who are undergoing this course, D.El.Ed.
Get the point. Get the point. Thank you.
And qualified will be given opportunity to apply in the recruitment process. This was the stand.
Yes, Mr.
And please note page 147 is the certificate given to us by our educational institution that our training is complete. And this is in June 2022. Page 147 of the paper.
Lastly, my lords, it was the board who then amended the notification to allow this.
Yes,
that is 29/9/2022, which is board's own notification that allowed us to participate. So board cannot take any kind of a dichotomous stance.
Who are you?
I'm just clarifying. I'm not a petitioner, Mr. Patwala said.
We filed an application for.
I'll just explain why I'm here.
Filed an application.
I filed 2 applications. It's IA 63429 of 24.
Yes, for implement.
Yes, and IA 174350 of 2024.
174350
of 2024. In the first one, there are 464 of us. In the second, there are 60 of us. Together, 524. We are not. I just want to clarify.
Who are you? Just.
I'm explaining. Just take half a minute. I'm not those NIOS candidates. That's perhaps somebody separate. That's a separate issue. That shouldn't be here. Who we are is, I am the D.El.Ed qualified candidates who had qualified it prior to the advertisement. Therefore, not like Mr. Patwalia's and Ms. Arora's clients.
Who applied prior to?
No, who had fully got our D.El.Ed well in advance of the advertisement, got our TET qualification, we were fully eligible. Now, because of the first order of your lordship, which said no merit list would be issued, which came in July, subsequently in January. Subsequently in January, and I'm saying because your lordship are taking this for final hearing, I'm not reading it out, but please do take a look at the affidavit that was filed by the board in compliance to the 22nd January 24 order. That has all the data, all the statistics, etc. And that's the reason I'm here.
22nd January.
22nd January. That has all the data. It will explain what the numbers are, how many applied, etc. Broadly, there are some 11,000 odd posts, 14,000 odd people applied. A few of them are held to be not qualified. They are eligible but not qualified. Some of them are held to be not eligible, which includes Mr. Patwalia and Ms. Arora's and Mr. Rahim's clients. They are obviously saying that they are eligible. Now, I am here only for this reason, that after this affidavit was filed in the Supreme Court, your lordships by this 29th January, and they annexed with them the list of those who had qualified. In that list of 9,000 odd, 9533, which is the number recorded in the 29th January order, I am not part of that 9533, even though I was fully eligible. Now, we don't know the qualifying marks at all. I didn't have an avenue to challenge this elsewhere because the merit list is frozen and being tweaked only by this court. Therefore, in March, I filed my application here saying, please just ask the board to divulge what the marks are of the qualifying so that I can know why I have been shut out and allow me to be permitted to contest that issue if it is made transparent. Right now, nothing is available with us. We know 9533 is the list that they have drawn up. Now,
That is a separate.
I'll just clarify, I'm not locking horns with them. Whatever they succeed, they succeed. But as far as I'm concerned, because the rule 8 is the relevant rule, rule 8 doesn't provide for any cutoff marks. So I'm not clear how there has been an exclusion once I have the D.El.Ed and the TET qualifications, and you have got a paltry number of applicants, in any case 14,000 odd against 11,000 posts. It's unclear on what basis my exclusion has happened. Therefore, as far as I'm concerned,
did you ever go to any court about this?
I came directly here. I came in March because I had no knowledge of the numbers until the last week. I did. I'm admitting. I'm just telling you why I'm.
This is not the way to challenge me.
This is not the way to interrupt me. No, please let me complete. Last week of January, I get to know because of the affidavit they have filed here. They don't let us know there. They file it here. So my plea is only this, fellows.
Okay.
Because Mr. Patwalia has made a without prejudice submission as well, that those vacancies, that 2,000 odd which remains, they can fully fill those up. My concern is there. That's why I'm treading on their toes a little bit. That just I'm just want to make my plea. Therefore, either my issue has to be considered somewhere. So if your lordships feel that it should not be considered here because you're dealing with a prior issue, that those vacancies should be held until my plea is heard either by this court or by any other court. That liberty I want to reserve because
the process was gone through in March.
They should have
2024.
This is something they should have divulged.
This is
about the basis on which I was called for the interview. I took part in the interview.
Okay.
Suddenly you say there are cut-off marks and I'm
Consider your case.
we need to consider. I'm grateful.
No, my lord.
Okay.
One submission.
My learned friends, matter is being considered. Your lordship has sent it back to court too. So your lordship will not be able to deal with all facts.
We are excluding.
Because we are part of the same notification.
Maybe
That doesn't help.
Maybe.
And our problem was the equivalence of 18 months to
All right.
years, and that has been referred to by report number 2 by my lords.
Okay.
Therefore, we only need to be protected. Some seats to be kept vacant for us. So tomorrow, if we get an order in our favor, we should have some remedy.
All right. Consider your case.
Yes. Lord, our stand is this. We had put it in the advertisement. Just see the advertisement which had come. That is to be seen, my lord, in page 7 of the order.
I have an urgent passover in the next court. I'll just do it and come. One. Great.
My lord, page 7 is the clause which was found to be objectionable by the division bench.
Yes.
Please see that clause, which is a
You
clause.
have seen your affidavit also, Mr.
Yes, yes. My lord, we had taken a stand.
We are in consonance
Yes.
with the stand taken by you with respect to the interpretation of the rule in your affidavit.
But my lord, there is one difficulty I'll point out, my lord.
Yes.
6.2, rule 6.2, page 5.
We'll go by the High Court judgment.
The candidate shall possess the minimum educational and training qualification as prescribed.
Yes.
Yes, page 5 of the interim judgment. Rule 6.2.
Yes. Okay. Yes. Tell us.
The candidate shall possess the minimum educational and training qualification as prescribed by the National Council, prevailing on the date of publication of the recruitment notification. So, my lord, what is to be?
It is to be
prevailing?
What rules subsist as on that date?
That's right. But if we look at the rules, TET is a qualification required.
Correct.
On the date of recruitment notification.
Absolutely. Right. Training. That's
Therefore, my lord, if they didn't actually have the TET qualification on that date, please don't keep interrupting. Please don't interrupt. My lord, what the qualification must be there on the date of the publication. Therefore, my lord,
are you changing your stand?
my lord, division bench, my lord, we are accepting the division bench stand. Division bench.
You change your stand.
Yes.
Why?
Okay. My lord,
Why?
My lord, there is no why. I am a counsel here, my lord. I am a counsel before your lordship, my lord. We are arguing a question of interpretation. We are arguing a question of interpretation.
Look, we can explain the reason.
Not necessary.
Because
we can easily understand.
No, I don't think my learned friend should hazard to explain the reason.
No, we will not even ask. We will give our own interpretation. What does it matter?
I have been given the reason, my lord, but that relates to the single judge, and I don't want to repeat that before your lordship.
All right, we'll pass on.
Now, so far we have succeeded before the division bench. We have succeeded before the division bench.
Okay, we should hear you. You are right.
Now your lordships, my lord.
Tell us your interpretation.
Yeah, but
you are supporting the High Court judgment.
Of course. My lord, your lordships can
just purely focus on law. We don't
focus on law, but your lordship always needs certain facts.
Not necessarily.
Now I tell you lordships why this has come up.
Tell us.
No, your lordships kindly see the pre-amended rules. My lord, that's have been given to your lordships by way of spare, my lord. This is additional documents at page 20.
8 of 5.
At 1424. My lord, IA number 142450. Probably the appellants for loss.
Tell us.
Place 20.
Tell us your points and given.
Losses, clause 6, your losses, my lord, rule 6, unamended rule 6. Page 20. My lord, so far, unamended rules, sub rule 1 of rule 6 remains as it is.
14250. 42450.
450. Page 20.
Page 20.
Rule 6, sub rule 1. At the bottom, your losses kindly see this remains as it is, both amended and unamended. This deals with the age. Normally, this is your losses will find in every recruitment rules that is to be age should be considered with reference to the first date of the year of the advertisement. So it doesn't deal with the acquisition of the qualification. So for unamended rules 2, your losses find the candidate shall possess the minimum educational qualification specified by the National Council for Teacher Education and the notification relating to eligibility of the candidates issued by the Ministry of Human Resource Development, Department of School Education and Literacy, Government of India from time to time, read with the relaxed qualification issued by that ministry from time to time past the date. But I tell you, losses in West Bengal, the training qualification was relaxed at that point of time. In respect to other state also, but the West Bengal. So this was the pre-amended rules of 2016.
Contrasted with the
and then your losses, page 423 of the paper book of your losses, running page 423.
What is
423. Your losses, since this was amended by notification dated 22nd December 2020, starting page 421.
What is the date of this?
Notification 22nd December 2022. 2020. 421.
Second.
December 2020. Page 421, starting page. The relevant page, your lordships, 423.
Yes.
Kindly see, my lord, sub-rule 2 of rule 6.
Yes.
The candidate shall possess the minimum educational and training qualification. We are concerned with training. As prescribed by the National Council for Teacher Education, prevailing as on the date of publication of the recruitment notification. My lord, why this amendment was done? Because by this time, the state of West Bengal got huge number of trained candidates, which was not available before 2016. So, my lord, this, my lord, if you lost it now, now your losses will find this was the rule. Number according to us, our submissions, one must possess the qualification prescribed by the NCT on the date of the recruitment notification.
All right, thank you.
This is one thing your losses. And your losses will find this on the date of the notification, they didn't have the qualification.
That's what your High Court also upheld.
Now your losses will find your losses will find your losses as per law laid down by this court in 2005, 2000 volume 5 SCC, page 262, paragraph 13. This has been quoted by the learned division bench. If I just take your losses, paragraph 13.
What is the citation?
Citation 2000 volume 5 SCC, page 262, paragraph 13.
Read relevant portion.
Paragraph 13. Now kindly see, my lord, placing reliance on the decision of this court in Ashok Kumar Sharma versus Chandesh Sekhar, Public Service Commission AP and such, and there are other judgments. The High Court has held, number one, the cut-off date by reference to which the eligibility recruitment must be satisfied by the candidate seeking a public employment is the date appointed by the relevant service rules.
This has been affirmed in the CB.
Now your losses, therefore, relevant recruitment rule says the date of the advertisement. Now, second thing, your losses. If there be no cut-off date appointed by the rules, then such date may be appointed for the purpose in the advertisement calling for applications. There was no date prescribed by the applications, recruitment notifications. Third, if there be no such date appointed, then the eligibility criteria shall be applied by reference to the last date appointed by which the applications have to be received by the competent authority. Exemptions by reference to the last clause, even they are not qualified.
No. Just
because they didn't qualify.
Just pause here. Now, if we have the recruitment notification, just place the recruitment notification.
Yes, my lord.
That is at page 219.
219. Yes, your lordship. Madam, kindly see 219 qualification clause 3 small b.
A single judge.
Consider recruitment notification. Now your losses page 219.
Yes.
Now, my lord, your losses will find it is to notify for all concerned that the West Bengal Board of Education is going to recruit TET qualified trained candidates, not untrained, my lord. Seeking appointment to the post of assistant teacher in government aided all these schools, statewide vacancy. Now your losses qualification clause. The selection, then before that, the selection and appointments of the candidates shall be made strictly in terms of the rules, as amended. But with all,
yes.
I say that this is the rules. 3. No person shall be appointed by the concerned district primary school council as on teacher unless he is a citizen of India and completed 18 years of age as on first day of January of advertisement.
Now, we have to interpret whether this part that PET qualified candidates who are undergoing so and so session 2020 to 22 and who have qualified in so and so examination will be given a part. Now we have to interpret this qualification.
This philosophy that is
yes, listen. We have to interpret whether this is in the teeth of the rule.
Exactly. Yes, that's the problem.
So now, if it is not in the teeth of the rule,
then it's valid.
Then they are eligible.
No, your lordship, I may answer to this. Malad, your lordship is concerned with second part of sub-rule B. Second, will never find either in the unamended or amended rules this clause. Never find.
What do you say about this judgments that we have?
May I add to your losses? Because ultimately I find your losses prima facie view is against me.
No, just reflect on it.
Let us try to now, therefore, your losses on the date, they were allowed by the board in contrary to rules as a pursuing candidates. They were pursuing nothing else because they didn't have their qualification. Board didn't have that much of power. But here I have to therefore, your lordship, the board didn't have that much about to include it. So this is in the teeth of the rules. Entirely contrary to rules. Well, I now tell your lordship two things.
Yes.
One is contrary. Well, if the advertisement recruitment notification is contrary to rules, your lordship's judgment, rule is prevail. Rule will prevail. There cannot be any.
Yes, that's right. Absolutely.
No doubt. What happened, your lordship, that should know your lordships. These persons, your lordships, find in the judgment under appeal that they were assuming that there will be a recruitment notification, they approached the learned single judge. The great honor learned single judge, your lordships. They threatened the board. Board is not in a position. That's why I told Mr. Gupta that he will not be in a position. That unless you include them in the advertisement, on the day itself, 29th, the judgment was passed, on the date of notification. I tell you, Lordship, this is the
serious objection to this kind of argument. This is not threatened at all.
Of course this was, and then other judgment I said.
We will not even accept such arguments here. You might be not used to
that's up to you, certainly, certainly. But one judgment I cite, another, your Lordships.
Not here.
2021. Yes, your Lordship, certainly. 2021 14 SCC, page 486, paragraph 6.4. 486, paragraph 6.4. Kindly see, these persons, my lord, got their TET degree without training qualification, contrary to the NCT notifications. Kindly look what your Lordship says in this judgment. Paragraph 6.4.
He was reading page 14.
Which para he was citing? Page 14. Not the date of all your sellers. If there is no cutoff being the date, it may be in the advertisement.
Running page
494. Page 494.
That will be page 494, ultimately, paragraph 6.4.
There are 6.4. Yes.
Well, may I read out your Lordship, very small paragraph. The judgment and order passed by the learned single bench, dated 8th May 2018.
1 minute, Mr. 497.
The judgment and order passed by the learned single judge, dated 8th May 2018, was the subject matter of appeals before the division bench of the High Court. By the impugned judgment and order, the division bench has opined differently as under. A perusal of clause 5.2 of the notification dated 11th December 2011, followed by this notification, NCT prescribed the qualification, recruitment qualification, clearly indicates that a person who is pursuing any of the teacher training course specified in the NCT notification dated 23rd August 2010 would be also eligible. This is for TET only. It appears to us that this benefit was considered to be given to such candidates whose teacher training course result had not been declared by the last date specified for filing the online form of the TET examination. That is why such persons who are pursuing the teacher training course would appear at TET examination, even they did not. In our opinion, pursuing any of the teacher training course should not be restricted only to such persons who are actually appearing in the examination of teacher training course. It should also include such persons who have been studying in the course, but examination had not been held. But what is important is that such persons should have been declared successful in the teacher training course before the date on which the examination result of the TET is declared. They didn't have the TET qualification, training qualification. Such interpretation is not given, then even a candidate.
This is decided on the usage of a separate expression called pursuing.
Pursuing.
That's what.
Your Lordships, if your Lordships kindly see the recruitment notification, clause B. Clause B exactly takes us to this situation. These were pursuing. Therefore, your Lordship, the entire notification clause was not in the teeth of the
anything in the
I need.
Yes.
Lordship, one page I need to show. If Lordship sees the paper book, page 1.
Yes.
Yes, Lordship.
Yes, Kunal.
Lordship, because my learned senior has said that in June the course has commenced. If Lordship takes page 139 of the paper book, 139 says, in November 2020, a notification was made. This is a notification of December 2020, which refers to the previous notification of November, which says the time when this course is to commence, 10th of November and will continue to 17th of December. That is the application period. So the course could not have commenced before 17th of December 2020. So 24 months will end after 17th of December 2022.
All right.
I just
What
need
are you saying?
I am for some of the respondents who have been appointed by an order of this court. Would just have that 29 January order for a minute.
Just one paragraph in that 29 January order, 60 seconds and I'm done. 29 January 24 order, 9533 were appointed. Para 3 is important, Manoj, and that Mr. Patwali has also
was appointed.
9533, Manoj, were the candidates who were appointed by an order of this court in the present matter. I am one of those, Manoj, whose appointments have been done after an order of this court, but Mr. Patwali is also not fairly disputing, Manoj.
No, I'm saying it's all provisional.
Well, that's what, therefore,
very much disputing.
Please come to para 3, Manoj. Because if the matter is being finally adjudicated, that one paragraph needs to be looked into, Manoj. Para 3 says, having regard to the fact that as against 11,758 posts in different subjects in various categories in all districts of state of West Bengal, the respondents have found only 9533 eligible candidates, including the additional panel of 5% candidates. It is deemed appropriate, very, very important, Manoj, to permit the respondents to declare the merit list with a rider that it should be stated in clear terms that the appointments made shall be subject to the outcome of the present petitions. The letter of appointments to be issued to the successful candidate, that's me, shall also specifically state that their appointments will be subject to the outcome of the present petitions. So the only point I'm trying to
subject to
outcome, Manoj, very well. So therefore, I will also have to be dealt with, Manoj, because this panel was as per the state rules, Manoj, this was done on 29 January 24. The panel expired on 29 January 25. So therefore, my appointments may be kept in mind, Manoj. That we'll see.
All that I want to.
For the 32nd, my lord. My lord, I am appearing for the NIS candidate, my lord.
Huh?
NIS candidate, my lord. Nationalism.
Dealing with that. Next.
But all that I want to say is, the rules don't contain a cutoff. Now, the judgment which is cited by my learned friend 2005, para 13, please have that. Para 13 says, the cutoff date by reference to which eligibility requirement must be satisfied by the candidate seeking a public employment is the date appointed by the service rules. And if there is no cutoff under the rules, then such date as may be appointed for that purpose in the advertisement. If the I can understand if the advertisement didn't contain that second para. The very fact that the advertisement contains a paragraph making us eligible. Please see para 13.
Yeah, specifically.
Yes, it specifically contains. So therefore, if your lordship finds that the rule don't contain a cutoff, the advertisement includes us in the process, then it cannot be said that we have to be excluded because of any reason whatsoever. And my lord, these are all the issue is, my lord, this is a peculiar situation which faced the board. Our training got completed by a certificate given on 28th June 2022. The board said, yes, we want to include this. The rule doesn't say, so far as age is concerned, the advertisement gives a cutoff 1st January. Qualification, it does not. It includes us in the process. So we cannot be excluded. That's grateful.
Written submissions can be filed within 2 days.
We'll see.
Short,
depending on.
Assistance to the court. The NCT notification has clarified what is pursued. My lords can see page 149. Page 149 of the main paper.
But that doesn't arise here because
I don't think it arises at all.
Clause doesn't exist.
Correct.
That would have arisen in that 2020-21.
Absolutely. Right? That will not arise.
We'll keep it simple.
Yes. Grateful. Very grateful. Very grateful.
Thank you very much.
Written submissions can be filed in 2 pages, Manoj, in a day.
Okay, do it.
Because that liberty will have to be
that judgment and then give you a flat. In 2 days.
Make us grateful.
This is the senior counsel. You can also file.
Yes.
Sorry, sir. So sorry, I didn't get your name.
Mr. Sanya.
Shubir Shanna.
Right. Thank you.
Grateful.
Deeply grateful, Manoj.
Thank you.
Obligation.
Yeah, please. I'm for the respondent, Lord.
40.
40.
We are on the same page.
Last one.
Qualifying service for pension. It's not really done. He wants a period for which he was never appointed to be reckoned for.
No, it is, my lord, this
Can't, he's not here. Anyway, we'll pass it over or?
completely right, High Court is right, my lord, I will satisfy that.
Pass. He wants, unlike the other cases where he has temporarily worked one thing. This chap says that I could have been appointed but for the delay process which has taken place. So therefore, can't be deemed to be appointed. 41. We'll have it on. We'll pass it over and see.
Yes, my lord.
Post lunch.
Or have it any other day.
Why any day? Today is a good day.
I am here.
Pass it over.
Yes.
Lord, I am for the first matter, Lord, I am for the petitioner.
So we require some time to file a reply.
41.
My Lord, I have been served with that.
Work promotion given to
I have retired. But the fact remains, this is the case of a Nostra problem.
You retired from
The innocuous order also that once it was dismissed by this one.
I am in 41.1 for the state of Odisha, my lords. In this present case, my lord, there has been a judgment by this honorable court, where they can say courts cannot directly pass a direction to the authorities, directing them to give them ad hoc promotion, my lords. In both the cases, I believe, in my case, bottom line is they have retired.
What happened to those proceedings?
Well, it's there pending, lordships. The trial is still
He is
pending.
retired from service. It's only retirement benefits that he should be given. Why are we getting into all this?
The respondent, lordships, in 41.
He also stands on the same footing like me. He is the employee.
He is asking, pending criminal case, please consider my case for promotion.
Please, lordships.
You are saying can't be done.
No, my lord, I also need that.
He is in the meanwhile, he is retired from service. We are asking you what happened to the pending proceedings now?
But they are still pending. No, no, no.
My lord, my learned friend is appearing for them.
And when have you?
My lords, there is little confusion, my lords. He is the respondent.
He is also the employee in the second match.
My lord, this
is for the state.
I am for the state, my lord.
Come on this side for the.
My lord, I am the petitioner, my lord.
For the second matter, you can come back.
For the lead matter, I am for the state.
Tell us.
Now, my lords, what has happened, my lords? They have retired, and the direction is to give them ad hoc promotion, my lord, subject to the outcome of the disciplinary proceedings and the criminal proceedings. In my case, my lord,
you first concentrate on his case first. So what? In the meanwhile, he has retired from service.
Lords.
First case we are talking.
Lords.
My lord,
Let me do one thing. Lordship will just.
They have that motion, huh? Please take instruction and close these matters. People have retired from service, and now his prayer for promotion is gone. It's only for retirement benefits. The calculation.
In this case, my lord, might be correct. Not in my case.
Correct. In this case, it's only a retirement benefits issue.
In my case, my lord, say ad hoc promotion, my lord, it won't be having much implication.
Lord, may I just suggest, my lord?
Even to come this side.
Lord, may I just suggest one thing, Lord? This is a matter they have find a reply only on Saturday. Lord, may posted for a hearing any Tuesday week next, because the next week is a holiday. In the meantime, let them take instruction, we can come out. Lord, we'll be doing that.
Putting the argument as if it's the great solution.
No, I'm only saying, Lord, they're just only
turning the matter, that's all.
There isn't Lord. They're just going to file the reply. Let them file it. And in fact, there are given to some of them. Lord, that's
what is to be done? You have retired from service, we will ask them to complete the
that they are not doing it. As early as matter has been stand still as it is, as in date in the 2014.
No, what are you expecting us to do? Because
Lord, may I just say that? Lord, they have just filed some documents.
That doesn't matter. What is the relief you
want? No, my Lord, your Lordship will just see that the first policy, their policy of the government policy does promulgate it that I should get an ad hoc promotion. What they are on today. Now, I have got an order, your Lordship will just see that. The order has been passed in my favor by the division bench. That has been come back and it has been filed an application for seeking a recall. And there the application has been, then the order has been recalled. That is what is the case in this first case, Lord. There is already an order by the division bench giving me the benefit.
How does it help you today? Because you have retired from service, we can't direct them to give you promotion.
But some notional promotion with a financial benefit has to come to.
Promotions will occur.
Lords.
When they are calculating the retirement benefits.
That's precisely.
So therefore,
that's only financial benefit which are. Lord.
what करके क्या कर सकते हैं इसका? हम declare करके consider करेंगे. Normally, come after.
He should repeat it.
That's right. What we will do, the only way you can do it is that we will expedite the departmental proceedings.
Since vigilance case.
Criminal case to be completed. Immediately after
There
that.
is already an order by the single judge. Nothing has happened since then. That's what the case is.
May I, Lord,
set it aside.
Lordship, may I request one? Even if they are given ad hoc promotion, Lordships, it would have no implication.
Meeting, we'll adjourn this
I'm
after.
going to have it at a big finish.
Then let it
Come back at
Lordship.
Item 32, I am to withdraw that petition.
Dismissed as withdrawn.
Much of it.
We have a meeting. Come back at it.
Very fine.
Please, Your Lordship. Your Lordship, here, it's a very short point.
It has become infructuous, my lord. I have withdrawn the money, my lord.
Your Lordship, they can still give the security. Your Lordship, I'm not a judgment debtor also in this case.
Right.
I'm the one who is holder of the registered sale deed. I have filed the original title deeds. And they do not, I'm not a judgment debtor in the decree passed by the trial court.
2018, I filed execution. Objection is 2022.
Because that is when I got the warrant for execution, and that is when I got the knowledge.
Why are you sweeping in between? So, interim order.
It is against the interim order. Lordship, I'm only asking that they should file security.
Run also.
Lordship, I showed my bona fides in filing.
1 minute 42. कोई इंफ्रैक्शन शुरू हो गया एकदम से पैसा विड्रॉ भी कर लिया
Lordship, I'm
Yes.
I am appearing for the respondent state, my lord, in this matter. We have filed the counter also, and the petition is there, sir. Below rejoinder, we received
7 का है.
yeah, day before yesterday, I received the rejoinder from them.
Nobody is appearing. Next Monday. Next.
Grateful to you.
Next Monday. Yes, 44.
We are in 44.1.
It's 44. I'm preparing for the state. Well, it's need a week's time to file counter.
Well, I have something to submit.
Well, it's in
12th of.
Can we give it next Friday? Next Monday?
I have no problem.
Next Monday.
12th August, your lordship issued notice for opportunity. Interim notice has been issued.
He is appearing.
Since 93, there is an interim order in my favor.
I would have not asked for it, Matters. I'd called for the officers in the plan. Lordships, give me some time, I'll be there. Even if we don't file it,
Your lordships can record last opportunity.
We don't know, man. We have dismissed a large number of such matters. Let them see. Let us see what.
Very well.
What is going on.
Let them come back. Otherwise, your lordships issued notice on interim also on 12th August.
It's all right.
I'll argue it out. No, there's no problem. Change the purpose. I will not doing on merits today.
Still on the very last week we get.
Very
well. We'll hear it next week. Next Monday.
Or maybe next
Monday, come back.
The only problem is these officers, my lords, they keep asking for the maps and all, my lords. That's the difficulty. Otherwise, I would have argued, my lords. Seeing the file, I would have argued.
As it is, he gets 2 weeks if it's 17th also, because 10th to the next week is not.
Most of
next.
Most of great.
10th March.
Item 45.
Please, I'm seeking 1 week's time to file the rejoinder balance.
Next Monday.
Please.
Okay.
A request of password.
May I, lords? Let the Dr. Singh is in another court without that.
On Monday.
Actually, this will need to be, because we have to do several judgments. No, 45. It will. Sorry, 46. It will. We'll need to show the legislation plus the several judgments. Would your lordship consider having it on a non-misleading state?
There's nothing, no documents. Why?
It's a pure question of law and squarely covered by a judgment of our court.
Yes.
There is a shorter way of doing it, there is a longer way, whichever lordship allows, the we are okay with that. The shorter way of doing it is, the impugned order relies entirely on Shilpi. My lord knows that lordship has referred Shilpi, but on another point. To be fair, it's on another point.
This is on limitation.
This is on limitation. This should also be referred because Shilpi is the reasons why it needs to be referred are 4 or 5 balance. Just note that why it doesn't apply. One is, none is prescribed in 2006 Act. Shilpi doesn't deal with that. It's already referred, it means no difference if it is tagged with that. Second, I'll give you 4 or 5 reasons. 2(4) of the Arbitration Act specifically excludes limitation. Specifically. for all statutory arbitrations. Your lordships amended the Arbitration Act many times, didn't touch it. The idea was that special acts like the MSME Act will not have limitations applicable from the Normal Limitation Act. It may have a special provision in its own end. 2006 Act was MSMEs are not well advised. MSMEs are always very slow. They have resource problems. So advisedly, two acts took the view. 2006 Act, not to have limitation. 96 Act, Section 4 excludes, 2.4 excludes. And then, the interpretation given here is that 2.4 itself is excluded because of sections 15 to 23 of the 2006 Act. I hope I'm clear. The impugned order says 2.4 is excluded. Now, I ask myself, 15 to 23 of the 2006 Act, nothing to do with limitation. Whereas your lordship's age-old principle is that if your lordship excludes this, it must deal with the subject occupying the same field, so one displaces the other. Then this requires consideration. So whether your lordship tags it or otherwise hears it, requires hearing. No problem. I have no problem. Whichever way.
Here it's still at 2
Yes.
o'clock. 2 p.m. Will you come?
Some indication lordship, it's a special time, so we know.
There are a list of 2 p.m. matters which will come.
Very good.
Is it
It's a rolling list, so it will be taken.
Next is a holiday.
It might even come in the month of March itself.
2 o'clock on Mondays, you lordship say.
Yeah, not Monday. Tuesday, Wednesday.
Very good.
One of these.
We will maybe check up later with the court master some indication.
They will check it up.
Great. We have got written submissions also already.
Yes,
No, Lordship, what does the 3-page note from each side? Please put it in. Lordship. Oblige.
So I'm seeking a Passover.
Passover. Yes, my Passover, sir, I took it. Lunch, what?
My lords, appearing on behalf of the petitioner in this matter, my lords.
Yeah.
Yes, my lords. My lords, after 5 years of being in employment, my lords, suddenly I have been laid off on the ground that I was ineligible because I possess a higher educational qualification. My lords, I would request my lords to.
Yep. Who is appearing?
I am for the respondent, sir, my lords.
Yeah.
It's here that appointment is.
Here we there is a judgment which says even with a higher qualification. Hey.
The appointment is actually contrary to the regulations of.
That's a higher qualification, is it?
My lords, it's not a higher qualification.
Why?
It's not equivalent actually because, my lords, the bachelorette, my lords, is 1 year course.
CPED means what?
My lords, it's a certificate of
BPED
physical education.
is different.
Certificate course, my lords.
Certificate is a higher course than.
My lords, it's a distinct course because there the teachers are also able to teach the primary students English, Gujarati, mathematics, in addition to physical education. Whereas
You give us a comparative of the.
Yes, my lords, the comparative, my lords, is also mentioned in the, my lords, it's there in my counter, my lords. We'll just have counter affidavit, my lords. Yes, my lords. My lords, my counter.
Where is the comparison of these two qualifications?
Please, my lords. My lords, page 5 of my counter affidavit, para 11. And as we just come to para 11, the certificate in physical education, my lords, and the distinction is this.
Para 11?
Please, my lords, page 5 of my
comparison chart.
My lords, it simply just puts
So
my lords.
how How many years is CPED course and
2 years, my lords.
And where is BPED?
My lords, it's a 1 year bachelorette course.
BPED is 1 year. He has undergone a 2-year course.
My lords, he's not undergone a 2-year course. He's undergone the 1 year course.
He has BPED. So then if it is a lower qualification matter, and
No, my lord. This is a higher qualification, has also been recorded in the impugned order as well.
Requires, my lords. In fact, in the first round, if my lords are late, in the first round when we had dismissed him from service, there was a specific order by the learned single judge.
Judgment of Jyoti KK is against them.
Against them. In fact, the other petition.
Jyoti KK, still you.
That's not his 49.
It doesn't really matter as long as the qualification is.
It's a post
prescribed qualification is not available, she can't get it. That judgment is, what do we do when we are in a 2-judge bench? Whether we agree or not, that judgment KK, Jyoti KK will apply against you. What do you say?
My lords may see page number 17, para 7, my lords. Para 7 of the impugned judgment, my lords.
Yes.
In the present case, the rule is clear to mention the qualification precisely. The advertisement was issued accordingly, and the eligibility was mentioned confined to such qualification. It was not possible to be construed for its any clarity to accommodate the candidates with higher qualification to be eligible. So I am of higher eligible. Not only I encompass the qualification required in CPED, but also BPED is the higher qualification, my lords. Plus, my lords, there was no complaint against me. I've been employed for 5 years.
Another judgment recently that it is for the employer to determine which is equivalence or not. And we can't keep sitting and deciding which is equivalent, which is not equivalent. And that the qualification is not equivalent is the finding of the single judge as well as the division benches court. The only unfortunate part of it is that you have worked from 98 to 2004.
My lords, precisely, and there is no other reason for me to get laid off except this that I was a higher qualification. No complaint, nothing. They have used my services.
You just ask her, how do you justify continuing them in service then?
My lords, it was after, my lords, when we terminated him, he had gone to the learned single judge. It was restored with a proper show cause notice on this very aspect. The interim arrangement for 1.5 years continued on the aspect whether BPED is a higher qualification.
Your first termination order was in 2002.
Please, my lords.
But then that is late. 98
Yes, my lords. In fact, what had happened, my lords, there was a relaxation of the services. This is an honorarium post, my lords. If my lords will just have the appointment letter, what they were getting was only 2,500 while in service without any other benefits. And today,
2004, are you out of service? Are you out of service from 2004?
My lords, yes.
20 years. 20 years.
I am employed right now, contractually somewhere.
Says salary, no further benefits. Therefore, my lords.
Unfortunate anyway. Sorry. Dismiss this. Simply dismiss. Next.
My lords, kindly, last submission, my lords. My lords, please stand.
Adjournment.
My lords, I would try to distinguish this judgment. My lords, kindly give an opportunity.
That's all right. So we have seen it. Thank you. High Court judgment is right. Next.
My placements. There are 3 matters, connected. After notice matter, it's complete, but in one matter, notice had to be served on one more respondent, it seems. And we need to file a rejoinder because they filed a counter 2 years.
Rejoinder counter was filed.
Yes.
So, in the third SLP, service has not been effected. I am the decree holder, so I'll enter where is the third SLP. Probably that notice was issued late in that on that SLP.
3 matters. Why?
Yeah.
Why are there 3 matters?
But list pendants purchases are filed.
No, not only list pendants.
Before that. Anyway, that's matter of contest. According to me, they are list pendants purchases.
Why should we hear a? Hear this task?
Yes.
You're not saying it. Is it because seems to be there is a contest and concurrent, though concurrent. What's the point?
My last maker will appreciate minutes.
Formulate your point of law.
Yes, minutes. Minutes. All through they failed to say they have been ready and willing, nor could they establish before courts below that they have had the wherewithal to purchase the property. Millets out of 43 lakh rupees, millets, they could pay 1 lakh rupees as advance, and then they dragged their feet. And they issued notice, I responded, then again they waited for 6 more months and they filed at no stage. Even at the appellate stage, they were asked to show their means and they filed a document. Millets, the Honorable High Court felt that the remaining amount to be paid was 10.5 lakh rupees. They have had 20 lakh rupees, it's been declared.
So findings of fact, my lord.
No, Millets, I'm just coming to.
We are pre-agreement purchasers. We have purchased, built houses over there. We are not even heard by the trial court or the High Court.
My lord, they couldn't show anything, my lord, from the documents.
Registered.
They were given several opportunities, what the High Court says. My lord, I'm a decree holder, my lord. Lord, I'll tell you, Lordship, the problem. The problem is, my lord, I'll tell you, Lordship, the problem. They have also, my lord.
Also, Mr. Mehta, but we have to hear it.
My lord, there is actually concurrent finding. There is no question of law. There is no question of law, my lord. I can tell you, Lordship, that.
They perhaps thought matter is getting adjourned.
No, my lord. They know the difficulty. There is, my lord.
It deserves.
May I suggest this, my lord? Because your Lordship may not grant leave, your Lordship may fix a date for hearing, my lord.
Matters to be heard which we are putting up, but not
Yes.
in the case, it's not possible. Next matter.
Great.
My lord, Lord, your Lordship may give some date, my lord, even July, August, some date, my lord. My lord, want the report to be continued.
Wait, please.
Who is appearing the 49?
Lordship.
Not some kind of interim, my lord, because I don't want a situation where it becomes fait accompli. Let's make it very clear, my lord. Lord, no, let them make a statement, no transfers will take place, my lord. I don't want any such situation, my lord.
It is my lord, already said.
Everything will
So, my lord, they will not create third-party interest. The Lordship may make it very clear, my lord.
means that.
Lord, we've seen, my lord, what has happened.
In contempt of your Lordship.
This pendants, my lord.
Do that one
After that, it's not the.
Throw them out in 2 minutes if you establish that. Sorry.
Great.
My lord, the liberty to complete the record. We'll file the documents of the trial court, my lord.
In the meanwhile, permission is granted to file additional documents if necessary.
At least hearing may be expedited. Lordship.
Great.
There is not a single case in which hearing is
Not expedited.
I know, my lord, Lordship is absolutely right. The only thing was, my lord, concurrent findings in a specific performance suit, my lord.
Great.
They get another lifeline this way.
It's more a council's requirement. It's saving.
The 49 Lordship recalls is on the interplay between SARFAESI and the Rent Act and whether SARFAESI trumps the Rent Act. Here, the tenant is seeking refuge under the local Rent Act to frustrate the SARFAESI proceedings initiated by the lender. Now, this matter, according to us, is squarely covered by your Lordship's 3-judge bench judgment, which he handed over. Bajrang Shyam Sundar. This is 2019 9 SCC 94.
Was that?
2019 9 SCC 94. This is Bajrang Shyam Sundar Agarwal versus Central Bank of India. 3 judges' decision. And 2 principles it lays, it discusses the interplay between SARFAESI and the Rent Act. And what it says is this.
Section 18 also, that's another.
Yes.
Appellate jurisdiction.
He could have taken that remedy. Order was of a DRT. They could have taken that remedy. They chose going before the High Court. Now, what Bajrang Shyam Sundar says is this. Is that if you are a tenant in sufferance, which they are, then SARFAESI Act trumps and overrides the protections that you may have under the Rent Act. That's point number 1. I'll place the paragraph.
Yes.
That's point number 1. Second, it says is, it relies on 107 of the Transfer of Property Act to say this. That look, if you have a unregistered agreement, which is the case here, then your possession of a secured asset cannot be more than the period that is prescribed under 107. So 2 things against the respondent tenant here. 1, he is a tenant in sufferance. Therefore, SARFAESI trumps. He has no protection of the Rent Act. Second, even assuming, keeping aside that first part, because today you have no registered agreement, your possession of a secured asset, and he is a tenant through the borrower, your possession of that secured asset cannot be more than the period that is prescribed in 107. That is the law which Bajrang Shyam Sundar lays down. It considers an earlier decision of our court in Vishal Kalsaria, which considers the non-obstante provision of section 35 of SARFAESI. Vishal Kalsaria was a case where this court held that the non-obstante provision of section 35 of the SARFAESI would operate only for laws that are operating in that area. That aspect was overruled in Bajrang Shyam Sundar by 3 judges of our court, saying that section 35 will override. That is a very narrow view to take. So it overrides Vishal Kalsaria, which is 2016, 3 Supreme Court cases, 762. We have filed a compilation of the judgments. So, on all 3 counts, this judgment in our respectful submission, holds the field and squarely covers this matter. Now, coming to the facts of this case.
When the lease was in subsistence.
That contains the provisions, and in fact,
Premises Tenancy
Act, Premises Tenancy Act.
Which is the year?
1997. 1997.
Originally, no, it must be.
No, the original act is 1956, which is the one that your lordship also would be familiar with. Yeah. There, my lord, section 13 laid down the conditions when you could evict a tenant. Now, my lord,
does it get modified by virtue of the?
It doesn't, my lord. That same conditions are now in section 6. The difference lies, my lord, in certain other aspects. Namely, my lord, if the rent is of a particular level, then the Rent Control Act.
96, no?
1997. Yes.
So, formulate your point.
Yes.
You are saying that this is a tenancy arising under the West Bengal Premises Tenancy Act 1956 as amended in 1997.
Yes.
So,
it wasn't amended.
Eviction is exclusively under 13 or 6.
Yes. So, my lord, the concept of
SARFAESI, another point is SARFAESI wouldn't override that.
No, I'll tell your lordship how the SARFAESI point comes into play. If it is a tenancy at sufferance, my lord, then the question of SARFAESI overriding might come into effect.
That is TP Act tenancy.
That's right. But, my lord, if it is a Rent Control Act tenancy, my lord, then you do
TP Act tenancy.
My lord, I must tell your lordship frankly, this follows Sondagar, which is a tenant, premises tenant, it's a Transfer of Property Act judgment, but it fails to, my lord, note any judgment relating to Rent Control Act, but applies the same principle.
Which is the act involved in?
My lord, here is the Maharashtra Rent Control Act. Of course, my lord, there was a section in the Maharashtra Rent Control Act.
In those kind of a tenancy, the concept of a tenancy in sufferance doesn't arise.
Exactly. That is my subject. The concept doesn't exist.
That concept is under the leases under the TP Act.
That's correct.
These are if he is a protected tenant, so to say.
Yes.
Tenant as defined thereunder, there is no other way of registering him except by the procedure.
And
unless we read now, even SARFAESI to be overriding the.
But SARFAESI will override only if there is some provision where there is a renewal being attempted, or if it comes to an end, if the tenancy comes to an end. If the tenancy doesn't come to an end, then section 13, this is
the clause here which the court has interpreted.
Clause is.
Where is the provision akin to section 6 or section 13? They have not quoted.
No, they have not quoted. They have not quoted, my lord, at all. Nothing about Rent Control Act. What is said is that there is, but in the previous judgment it had been stated in Sondagar.
Rent controls and other statutes.
Now, my lord,
let us see the overriding clause.
Let me indicate one more thing to your lord. 35. My lord, that part of Vishal Kansaria was not overruled in Bajrang, that which Bajrang Shamsundar, which said that landlord cannot achieve what he cannot achieve under the Rent Control Act by taking advantage of the SARFAESI Act. Now, my lord, this judgment, my lord, if it is interpreted to mean this, then it would be possible for a person to, my lord, circumvent the Rent Control Act by saying that I am now availing of the SARFAESI Act.
And the converse is true as well.
And the
converse is true as well.
No, my lord.
Which is what is happening. The borrower is behind my learned.
Now, your lordship, I will show your lordship, my lord, that in
the last occasion I had observed this as an euphemism. The borrower is standing behind them.
My lord, no. Borrower is not standing behind me. My lord, I am a landlord. I am a tenant of a much earlier period, my lord. Now, I may tell you, lordship, one more thing. That Bajrang Shamsundar can be justified on the facts of that case. There is, my lord, a finding that the tenancy created was not a bona fide tenancy created. Now, in our case, my lord, this tenancy has been created by the previous landlord long before, my lord, this loan was taken. Not even this landlord. The previous
in 2007.
Exactly, my lord. He purchased in 2007, then took a loan, then defaulted on the loan, and my lord, now he is trying to take advantage of it, my lord. Yes.
That is the reason why these are not a writ proceeding. We should have gone to the statutory appearance.
Therefore, that was our submission. And my lord, what is
no, my lord, now what has happened here?
Today, there is no agreement.
I tell you, lordship, why the way
27 expired in 1992, my lords.
There is no expiry. My learned friend, my lord, is making a fundamental mistake, as I told you, lordship.
Not over this.
This whole concept, my lord, that a rent control protected tenancy. The eviction petition is pending, my lord. I have got a stay.
You say about that. Those eviction proceedings are pending.
No, that is why.
Makes no difference.
Makes no difference because that is by the landlord. That is by the landlord. And today, my lords, we have followed 13.2, 13.4. 13.2 is pivotal.
Sorry,
we are not on. My friend is not raised.
What? Sorry?
The eviction.
The eviction petition was filed by the original landlord.
Original land. original landlord. This landlord, not the person I took the tenancy from. After I took the tenancy, several years passed, then sold. Yes, the purchaser will not proceeded under the Rent Control Act.
R2, so to say.
Yes, correct.
Find an EP against you.
Yes, and therefore,
Filed an EP.
where is the agreement then? Because when he himself has filed today, because it is.
These are all you have also not brought them on record, nothing on record about the initiation of the, to just get an inference as to whether the concept or the portrayal that himself is a statutory tenant is genuine or not. For that,
It is. Kindly see page 21, his own position. His own position at page 21 of his SLP is that this is an oral agreement. Today, the original agreement was of 87, 5-year agreement. That agreement has expired.
Six or
yes, tenancy.
It was the act.
Yes.
And which is the first indication that the protection of under this act is sought? When do we get that and where do we get it?
Yes.
When did you first claim, Mr. Gupta, the tenancy rights under this act?
Yes. This is after the dismissal of the borrower's petition. Before
what they did was, they went to the section 14 court and got us dispossessed.
Act is what we want to know.
Milord, first of all, Milord, the eviction proceedings, Milord, is going on.
That's what I
Yes.
about to ask you that.
Yes.
When the respondent number,
the landlord,
yes, perhaps respondent number whoever,
two
are two purchased it.
Yes.
From the original owner and
yes.
tenanted it to you.
Yes.
And R2 must have initiated proceedings.
R2 initiated proceedings. He did not create the tenancy. He adorned the tenancy.
You know that.
He adorned to the tenancy.
Where is that initiated?
Yes, Milord.
Where is that
eviction procedure?
That was done in
Milord, I'll do this, Milord.
2008 it was initiated.
Yes, Milord. After purchasing it, Milord, he initiated proceedings. I will put it on record.
I don't have the papers.
I'll put it on record.
We just want to know where it was initiated, under what act it was initiated.
Yes, yes.
You can just orally tell us.
Milord, I don't have it here, Milord. I'll keep it tomorrow, Milord.
Determining.
I'm not. I wrote it for myself.
Where did he file and did he specifically invoke the West Bengal Act and seek eviction on one of the grounds specified in it?
Yes, my lord. That is, my lord, my.
If he, because it's unlike the tenancy, unlike the Transfer of Property Act, eviction can be only under specified grounds.
That's right.
So did he invoke this act for evicting you?
Yes.
Assuming that you are a protected tenant.
Yes, ma'am. I'll put that eviction petition on record tomorrow morning.
You'll see that. You'll see that.
That's the only thing you should see.
We'll see that.
If that's the case, then you'll have to see. Not that we're going to close the chapter.
That's right. Because there are certain.
If that's the case, then we will have to see to what extent SARFAESI overrides even judges.
Just please note para 33 and 34 of that judgment. That Bajrang 34 puts at rest my friend's submission. Because today his agreement has expired in 1992. So therefore today he's a trespasser.
No, that is the incorrect thing.
He's a trespasser today.
My learned friend is continuing to make a submission which is contrary to all authority.
I will show.
Because the
agreement is expired.
Because the judgments have not been taken into consideration.
What right do you have to be in the property once the agreement has expired? Please see 33.
I think rent control law is being simplified a little too much here. It cannot be terminated under 106.
No.
Because it's protected.
Only by virtue of certain grounds you can be evicted.
Yes.
Those grounds are specified.
Yes.
So therefore it starts with notwithstanding.
Yes.
That means there has to be a termination of tenancy and thereafter institution of a ground specified.
No, my lord, there cannot be a termination of such tenancy.
Efflux of time it terminates.
Efflux of time.
No.
Because the agreement. Where is the agreement?
I'm sorry, my lord.
Anything contrary contained in
any other law for the time being in force or in any contract, no order or recovery of possession shall be made by the controller in favor of the landlord except on an application in one of these grounds.
So these are the grounds.
Yes.
So before you invoke the grounds,
yes,
there has to be a termination.
No, ma'am.
Unless it is a case brought under these grounds. Now suppose you are a defaulter.
Yes.
The landlord has an option to not to terminate your tenancy.
Yes.
Now if he terminates your tenancy and then institutes a suit on the ground of default, then it will be covered by this.
Yes, sir.
So tenant at sufferance would be a person whose tenancy has been terminated either by efflux of time under the contract or by a notice under section 106.
No, my lord, not in a rent control proceedings at all.
Right?
Tenancy at sufferance doesn't arise under rent control proceedings.
These are only the grounds on which an eviction can.
There are no other grounds possible, and your lordship.
No, that's a different.
This is the subject matter of 3 judgments of this court, my lord.
We have to.
We are proceeding with the matter.
No, we have to consider whether this judgment, which has been
submitted before that, my lord, your lordship.
Was the field or not?
All right, very well, my lord, but your lordship will definitely have to see whether the relevant judgments for Rent Control Act have at all been considered here.
That is what we are going.
So there are 3 judgments, my lord.
Yes.
There are 3 judgments at least of the Supreme Court.
Yes, you argue, we'll hear it.
Yes. So, my lord, he has filed eviction proceedings under this act against me. No. My lord, we had given your lordship, my lord, 1 judgment on the last occasion. Vishwabani?
Which judgment have you given last time?
I think Vishwabani I gave your lordship, my lord.
It gets adjourned, Mr. Gupta.
Lordship?
Grand memory goes away.
Sorry.
There is no hard disk which we carry. But your foundation will have to lay.
Yes, sir, of course.
Foundation will have to lay the foundation before proceeding further.
No,
One minute, you understand what we are saying.
Certainly.
Foundation you will have to lay by saying
that
you claim to be a tenant under this act and that the landlord initiated proceedings under this act.
Then keep it tomorrow. I'll produce the eviction petition. Please concentrate on the question and the answer. This tendency of not answering the question and saying something else is not good. I'll put the eviction petition on record. I'll put the eviction petition on record, and then I'll lay the factual foundation and then I'll show you. Very good.
What the position is to
my learned friend is asking for a little time to get the petition, Millard. Next Tuesday, if you're Tuesday is not possible. The week after that.
Tuesday is a fixed date.
It is Monday, Millard, but not next Monday because that's a holiday. Keep it on 17th if you like. 17th if you like.
Both of
Yes,
together.
we'll do that. We'll assist you along. Look, my friend has a difficulty on 17th. Any other date? I'm 18th.
18th is fine, but my lord said that Tuesday the
19th
are a problem. No. I'm not asked. I don't have a problem with 18th.
19th then.
19th also. Millard, is it for 2 p.m. Millard, or is it in the list? In the list, whenever it comes up.
What he was saying.
Under this act, just indicate, if I may just indicate, my lord, subsection 4 of section 6 is the one which deals with notice if you wish to initiate proceedings under this act.
You see what you have done, what they have done against you.
Yes. Yes. For all grounds, a 1 month notice is required, except for one ground, which is E, which is if a notice of quit is given. Notice to quit is.
Anyway, we will spend time and we are.
Yes, my lord, I bow down.
Grateful.
Dodge.
This item 50 minutes, I am seeking time to file a rejoinder minutes. In the meantime, may I request additionally?
मेरा special bench है कर दीजिए.
Lordship, I'm seeking a short adjournment. Lordship is leading us.
We have to await CV in this matter. Tell us, what do you want?
A short adjournment of weeks time.
Yes, I would also require 2 days to file this counter affidavit. It's a 2 day Lordship.
A post after 4 weeks. Next.
Grateful Lordship.
I'll file rejoinder if much.
I'm seeking 2 weeks time to file rejoinder.
All right, adjourn. Request.
Grateful.
53.
Your Lordship, I am seeking 4 weeks time to file counter.
Go ahead. Why? It's only just a second appeal dismissed on the ground of delay of 311 days. And what adjournment in this? Either one will restore it, go and argue it.
Please, I'm not sure.
Is there a, why you should be adjourned in a matter like this?
I am requesting to file the counter.
Out of a suit of 2011 and we dismiss it on 182 days. 2011 suit and
कब का डिस्कशन करें ना करें बोलो आप तो कर दिया करना नहीं कर है ना मेरिट्स पे करना है मेरिट्स पे क्यों से डिले है
we decide on merits.
we will decide तो हाई कोर्ट डिस्मिस होंगे में ग्राउंड then set aside इतना ही ना okay just write will dictate to you later because the first portion of facts, you say the appeal arises, leave granted, appeal arises from the judgment. Contempt कौन सा है? 53 एक मिनट. क्या reasons थे?
Paragraph 4.
There is absolutely no justification for so and so. Okay, this appeal arises out of judgment of the High Court of so and so, dismissing the second appeal on the ground of delay. Stop. Delay of so and so days. Heard learned counsel for the petitioner and the respondent. The High Court was of the opinion that there is no justification. Justification to condone the delay. Having considered the matter in detail, we are of the opinion that the decision of the first appellate court being of a reversal and that the petitioner is admittedly not in India to diligently pursue the matter and take to consideration that we are inclined to condone the delay. Further, the first appellate court allowed the appeal on the ground of adverse possession. Or carries on there. In this view of the matter, we, in the interests of justice and in order to give full opportunity to the appellant herein, we set aside the judgment of the High Court and restore the second appeal to its original number. The High Court shall give opportunity to both the parties and decide the second appeal as expeditiously as possible. All right, we disposed it off. Facts थोड़ा सा add. Next, please.
Let's indicate the date, Let's indicate a date before the High Court.
Get restored.
Please, Your Lordship.
Yes.
Yes. The question of law is at page 10, wherein.
What happened? What happens in this?
No, this is a case where a committee was formed, local committee for high pitch assessment.
Oh, high pitch assessment.
Yes. In 2015.
Why are you unnecessarily wasting your time in the jurisdiction like this instead of just you filed already appeal?
No, I have already.
Appeal is pending.
And he has paid.
You see, that's what I am saying. The committee was formed. If your lordship see page 42 of my compendium, it was formed to redressal of the high pitch
grievance petition was rejected by the LCH PSA. I don't know what it means. On the ground that it is not a fit case.
No.
But is that's not a statutory right?
Yes, yes, that's what I'm saying. Kindly see page 40, 400 page. It has been constituted under section 119 of the Income Tax Act 1961.
Anyway, what happened to your appeal?
My appeal is pending. But notice a CBT circular was issued by the behest of the Deputy Prime Minister that any assessment.
What is appeal? Just tell us if he is entitled to pursue this under the scheme or not.
No, his case is considered and rejected. He has filed a review that was also rejected. Now his appeal is pending and he is directed to pay.
It was rejected on merits or was it rejected?
It was rejected on merits. His complaint is that I should be heard by the committee, which it does not contemplate. We have called for the reports, found it is not a high-pitched assessment and rejected it. Now his appeal is pending. 7.5% is paid as a condition of stay. Normally we insist for 20%. It was only 7.5% and assume that he must have paid. And stay is there till March end.
Show us that grievance high pitched one. Where do you get that? Show us the provisions.
Please. That is at page 42, Your Lordship.
Why should we get into it once it is held that it is not a high pitched?
No, you see, it is.
You are regular.
No, Your Lordship, there is a circular which says that if the assessment has been made double the amount of the returned income, then it is definitely held to be high pitched assessment.
Anyway, sir, they haven't.
Circulars are binding upon the income tax authorities, and this committee has been formulated for the redressal of the taxpayers because of the faceless regime. Now, faceless regime, they don't hear. We are not sitting face to face. Whatever they say, we file a reply. They don't hear us and pass it. In my case, Your Lordship, for the last 16 years, they are holding the revenue I am giving to the other concern as the revenue expenditure. Now, all of a sudden, after 17 years, the new assessing officer comes for his biased nature. He says it is a capital in nature.
You are arguing so much. Your appeal is also pending.
Yes, Lordship, but my humble submission is the committee constituted in 2015. Kindly see page 28 of my compendium. The CBDT chairman has said that he is unhappy with the working of these people. What for? And now kindly see. Kindly see their.
Thank you. I think you leave.
Kindly see their reply. You know, kindly see their reply. I'm not asking anything. I'm not asking anything. Stay around. I'm only asking that they should hear me at least. That is my.
Not one
right.
hearing, sir. Multiple hearings were given.
No, Your Lordship, they have not given me a single hearing. Your Lordship, the committee has not given me a single hearing. That is what I am here. And I'm kindly see my question of law is also that they should hear me. Why they are
the provision?
C8 page 47, Your Lordship.
Just show us the provision.
TDF page 71. What is the scope of interference?
No, not like that. Show us the provision. Whether it creates a right or what. Just
no, it is under 119 of the CDD.
Yes. Page 400, Your Lordship.
400?
Yes, Your Lordship, of my compendium.
There's no 400 here.
399 is the constitution, revised instruction for constitution, and at 400, taking into consideration the changes, organization set up subsequent to launch of faceless regime, 400, Your Lordship, of the SLP, in exercise of its power under section 119 of the Income Tax Act, and its suppression of early instructions, so the following instruction regarding constituent functional of the local committee has been formed. and in their reply, they say it has got no.
1 minute.
Please.
Wise instructions, see digital as the right step. It's a kind of thing.
Initially, it was created at page 42, Your Lordship.
It is the nature of a scheme. Which is the
page 405. The grievance petition received would be examined by to ascertain whether there is a prima facie case of high-pitched assessment, non-observance of principles of natural justice, non-application of mind, or gross negligence of assessing authority. Only to that limited extent, we can interfere. And the committee found, it is not falling within that category. Now, on merits, if he has grievance, the appellate authority will take care. Appeal is right for assessment. Let him go ahead. Let there be direction to decide the appeal.
Your Lordship, then they should scrap it. They should scrap it.
Thank you.
Kindly see my humble submission.
Thank you.
This is only
counsel for the petitioner.
Your Lordship, kindly
decline to interfere with the order passed.
let me finish my hearing.
Not entertaining the petition under the grievance
passing a
petition, we direct that the appeal filed by the petitioner, number so and so, be taken up and disposed of within a period of 3 months from today.
Kindly see, just for a moment.
Sir, we have passed order.
If the income tax department constitute a committee for the redressal, and it says that a high pitch assessment, kindly see page 2
is pending, sir. Please.
Your Lordship, but
thank you. We have passed.
Then Your Lordship pass an order that they should scrap this scheme.
That will pass.
What they are saying.
Challenge the validity of that scheme. We will challenge it.
You see, honorable.
Thank you.
Honorable. And the last time also I have given the copy of Honorable Allahabad High Court has interfered, and where Solicitor General of India, Additional Solicitor appeared, and he has said, and they have agreed that we will do justice with
the next case. Thank you.
Yes. You kindly see, this is a.
Thank you.
I'm only
past orders, please.
But just for a moment, I'm only seeking that I should be heard.
All right.
And that is my statutory right. Kindly see the judgment. I have given 4 judgments. Sahara, India.
Please don't argue like that when we have passed orders.
So once Your Lordship, I am not finished, and Your Lordship will pass the orders without going to the facts of the case, the legal provisions.
Thank you very much. On the next case.
You don't have to say thanks to me without hearing me.
Thank you very much.
Your Lordship is
to ask or not, we don't
Your Lordship is here.
Ask for that.
Sitting here to hear the litigant.
The next case.
Very few
for
people
the petitioner item 55, my lord.
If Your Lordship will not hear me, and kindly see, my question is only that they should hear me. Why they are afraid of hearing me? Why?
It's pending, we told you. All right, you leave.
But then Your Lordship pass an order to scrap this scheme. Why they are wasting time?
All right,
In my case, 20 lakh has been wasted coming up to the Supreme Court.
Enough, we've heard you now.
No, Your Lordship has not heard me. Your Lordship is hearing me with close mind for the next case. I don't think next case is more important than me.
Yes, thank you. Now,
see the public interest.
Thank you. Now, there's enough. We have told you.
I don't need thanks. I don't need thanks.
You don't need your.
I want to thank you. Your Lordship, hear me.
Okay, go ahead.
That is
my
not
lord, I pray for
justice, Your Lordship. Your Lordship has held a number of judgments that one must hear of the length. Your Lordship has not heard even for 2 minutes.
Right, all right. Now come on. Tell us.
I pay for the petitioner in item 55, my lord.
What
my
is
lord, this is a matter which arises out of a pre-institution mediation, where the trial court had held that the exemption for pre-institution mediation is not required. They challenged it respondent 1 before the High Court. After that, I have challenged the High Court order. My lord, in this case, a lot of water has flown after that. Injunction hearing has happened. So the issue of pre-institution mediation, in my respectful submission, has also become infructuous. So I wish to withdraw, but my lord, I'll just pray for one small thing.
The point is an important point.
My lord, I
okay,
agree.
We will.
Only one thing is a detailed withdrawal may be passed with a little bit of facts, because they're using the High Court order before certain state authorities to get the license.
Yeah,
So it may only say, yes, my lord.
What is that once you are withdrawing?
It may, my lord, please, my lord, one small thing. It may only say
that you should give a reasoning in that. Then it is become infructuous is what you are saying. Then it makes no.
My lord, it may only say I wanted to press this matter. I thought it fell from my lord last time that injunction hearing has happened or not. I actually wanted to argue this matter because this is a very important question of granting.
But you are withdrawing, no?
No, my lord. Then in that case, please allow me a week. Maybe let me just come on physically and argue this matter. It's a very important question.
So what will satisfy us? We thought it's important, but you wanted to withdraw.
No, 1 week. Just allow me 1 week.
Who is appearing on the other side?
I don't know, my lord.
It's an after notice, right?
It's after notice, my lord. I think the opposite side has been served also. It's in the office order. However, they're not appeared. They're not entered appeared.
This is 55.
Well, service complete has been.
It's service complete.
Okay, do one thing. Inform the other side. Come on next Monday.
Will do, my lord. Apply.
Go ahead. 56.
Excuse me, Lords. Lords, as per the office report, the service is complete upon the respondent, but the main respondents R1, R3, R5 have not filed their reply.
Is the state is appearing here?
State is not required. It's only a recovery certificate. You have to follow the revenue code. State has no role in this matter. It's the interested fight between an allottee, Ansal.
Who is appearing against the
State actually not a necessary party at all in this.
But R3
is
contesting party.
R3's reply may be required. R4 is the builder. R3 is the district magistrate who's conducted the auction. R5 is the auction purchaser.
Kindly 3 weeks time may be given to file counter.
And your lordship, I'm appearing on behalf of UP RERA, respondent to the counters already filed and on record.
R2's counter has been filed.
Now they've come. File a counter immediately.
4 weeks.
Post after 4 weeks.
I'm grateful. My lords may give me liberty to file the rejoinder.
Come after 6 weeks. In the meanwhile, counter and rejoinder will be filed. Yes.
57.
Please, well, it's happy for the state. I see time to file now.
May I be given 2 weeks thereafter to file my
I may request for 3 weeks.
This is covered by that
MP
Road Development Authority.
LG Chaudhary.
It's covered by that judgment.
Please. Problem is that
Take a note of that judgment.
It's covered. It's adequately addressed in the pleadings. Only confusion that
Road Development Authorities.
Yes, my lords.
Have you seen that judgment?
My lords,
It's only that subsequent order.
I'll file my counter.
Just after 4 weeks. The case getting adjourned. Next.
Yes. Next. May I be given liberty to file rejoinder? Very grateful. Very grateful.
Lordship, I kindly grant you 3 weeks time to file rejoinder. Counter has been filed. Will be taken up after holy vacations. After 3 weeks, Lords.
Some date may be fixed. The arbitrator has entered and fixed it up.
Next.
But
we'll give you some date.
Very good.
It will be indicated in the order.
Very good. After 3 weeks, Lords. I'm grateful.
May it please the Lord. On the last occasion, the state was asked to seek instruction by the order dated 22nd of January 25, by which the High Court.
इसी में चला.
Yes, by order dated 22nd of January 25, your Lordship had asked the state to seek instruction. The issue in this matter is this. The respondent, he had a disability of less than 40%. The appellate authority, in terms of the notification of the state government, had said he has a disability of less than 40%, therefore he is not entitled for reservation at all. He is under the Disabilities Act. Now, my lord, he goes before the High Court
and High Court refers it to an authority which is not
Second time.
Yes, second time. And then the said authority says, Lord, he has a disability of 60%. On the last occasion, when your Lordship issued notice, your Lordship asked the state government whether it's a real authority. Lord, for that, Lord, if your Lordship sees page 41, the actual authority, the appellate authority who says he has a less than 40% disability is page 41. The JJ Group of Hospital, GMC. Now, the JJ Group has said he has less than 40%. Therefore, your Lordship on the last occasion asked the state government to find it out, verify and find it out. Page 41, if your Lordship sees.
Yes, you're there.
The second serial number, the first issuing authority is all medical colleges, the government and municipal corporation. And then if you are dissatisfied with it, you go to the appellate authority. The appellate authority is Dean JJ Group of Hospital, GMC, Mumbai. Now the appellate authority has said that the respondent's medical, the disability certificate is not right, and appellate authority says you have less than 40%. That your Lordship would see. Page number 74.
But
at the bottom.
Maharashtra mental health conducted the test and then it said in fact is more than 40%.
Yes. Now, no, that time it was said less than 40%. Page 74 if your Lordship see. At the bottom, impression, last word, disability less than 40%. And now what happens is after the impugn judgment, please see page 1. Page 1 of the impugn order.
Taken instructions.
That's what I appear for the state. We've taken written instructions on this issue. As admittedly, that authority is not the authority to pass a disability certificate. It is only an authority to provide a recommendation if at all.
Where is it?
Your Lordship, I apologize, we couldn't file a counter in time. Have written instruction, give me a week.
If that is done, then I think we will allow it.
Yes, it will have to be allowed.
To file it.
Great for Lordship, but we can make even a Friday Lordship. We'll have it filed within the week.
Come on Friday, come on.
Great for
Friday.
I appear before the respondent.
Okay, what you do is you serve a copy on the other side. Let him serve a copy on you. You are appearing on whose behalf, Mr. Arthur?
I am appearing for the candidate whose ability is being questioned in this.
Then you will have to serve a copy on him, you will have to hear him.
Lords, I am appearing on behalf of.
Their disability is varying every time.
After 2 weeks.
Lords, I am appearing for an intervener.
Monday will not opening on the opening because now they appoint.
What's on Monday?
17th.
17th. In the meanwhile, you give it and we will hear you.
Yes, very.
Lords, I am appearing for an intervener. I may also be served. I have a very limited role here.
Where are you coming?
Lords, I am one of the. Sorry.
Or who are you appearing?
Lords, I am a successful candidate. We have already received an appointment order. I only apprehend that in the dispute between the two of them, the entire proceeding should not be stayed.
Don't worry.
That's my only concern. Other than that, the dispute is between.
My friend doesn't have to worry. I'm so glad.
As it is, this litigation is not enough.
My certificate was never in question. The tribunal passes a general order and includes me despite the fact that he includes only 3 other persons. Now, my lord, it is ought to be said that because of the general order that is passed by the administrative tribunal, you become disqualified.
You will have to hear him. Yes.
I am so
obliged.
File it without fail.
Yes.
So that.
Monday?
Monday?
17.
Why would I say 4 weeks to file counter?
Yes.
Lordship, this is an after notice matter. Service is complete. The respondent is appearing.
You wanted some time?
Very well, Your Lordship.
He's been in jail for 3 years. The trial has not even started. One witness was examined. Then the prosecution says we need to summon more witnesses.
Fresh matter, no?
Yes, Your Lordships.
Wait a minute. It's not opening.
And with great respect to the High Court, my lord, it just extracts the FIR, says they are grave.
Happening.
Let them come and see.
How do you explain the money trail from your?
So, in fact, I told my client that this is something which was before the High Court and they have my lord, let's look at this. So the main accused, Lord Justice Mishra is right. The main accused is one Karandi, some jilted lover, my lord. And this gentleman, the petitioner here, was a friend. So was he a pawn or a mule who was told to transfer the money to the so-called...
The person who has been killed has no link with the motive shown in the FIR.
Yes.
Apparently.
Yes.
But the allegation is that there was some money transferred to the hired assassins from your account.
Correct, my lord. Please
just
this...
paragraph 6.
Correct. Now please see this statement, my lord. Someone owed money to the main accused Karanjit. Would your lordship just see in the middle of the page? This is one Anurag Gupta, my lord. Because the main accused father, they were in the business of trading in rice, I think. Just see in the middle, mostly Karandi, which is the main accused, does business with me and the money I owe him, I used to transfer money in cash or transfer at the request of Karandi. Yes, I had to pay 1,80,000. On so and so, I got a call from Karandi that I have come to Srinagar for domestic work, etc. And I transferred the money on the say-so request of Karandi to his friend Muhammad Saqib, which is the petitioner before my lords. Now the High Court, my lord, doesn't even look at this. It just says it's a grave. According to this gentleman,
When you were arrested?
Lord, I was arrested in 26 February 2022, Lord. I spent 3 years, Lord. I have a child that was born while I was in custody. Lord, and 42 witnesses. Returnable data. Returnable data. We'll serve the standing.
3 weeks?
3 weeks. And we'll serve the standing. We'll serve the standing counsel.
Yeah, sure.
People of that.
We file that document also, you know. It's not what I showed my lords, we file that.
File it.
May it please, Lord, I am a cooperative bank functioning since 1919. This is a lot to cater to the needs of the employees of Northeastern Railway. And we have members from 3 states because Northeastern Railway Block functions in UP, some part of Bihar and some part of Uttarakhand. It becomes multi-state, yet not. It's been rejected because they say that, well, you have to show that your bylaws say that you are not in one state. My bylaws say that. Just have a look at my bylaws, not page 110.
No, we haven't seen, but by your submission, if you go by that, there is no reason to deny.
Absolutely no reason. And because of that,
just have a look at
Lord, just have a look at the reasoning. If your Lordship has. Yes, yes. Lord, if your Lordship has page 27. Just 2 pages I'll read. 27 and 28 seem to be the reasons. And they say you have given. They say actually what they did was not they.
As well as the extent were enacted for the purpose of view of the judgment in Panduranga.
The Act very clearly says that if your objects are that you are not confined to one state, then you become multi-state. There is no special thing about Malad, and I admittedly I have members in Bihar, etc.
Where is the reasoning?
Page 27 and 28. Though the petitioners claim to have members of the state of Bihar, it has not been demonstrated by them that they were granted license by the Reserve Bank of India to open an office in Samastipur in Bihar. So this is a chicken and egg problem. Namely, the RBI will not give you a license till you are multi-state. And the High Court is saying, well, because you have not got a license from RBI, therefore you can't be multi-state. The the Act says that before the 1984 Multi-State Cooperative Societies Act, if you are functioning in more than one state and your objects did not limit you to one state, then you are deemed to become a multi-state. The 1973 bylaws specifically say that I will function wherever this Northeastern Railways.
In paragraph 48, he accepts that you have a multi-state.
Yes, my lord. However, that's our problem. It goes into one detailed this thing of Lord, what the old acts were, etc.
They say that you can't be deemed to have this registered under 2.1 of the Act. Yeah, they should notice. Take on notice.
Status quo, my lord, because otherwise they are closing everything.
No, just take on dusty notice.
There was an interim order in the High Court. Just pass on that. There was an interim order in the High Court, same order. I'm sorry, my lord. So they are closing my department, my lord, branches or the counters in the other states because the RBI says and UP registrar will take over. And the UP registrar will take over. Just take the High Court order. Yes. Just let us see the copy. Well,
Status quo.
Great.
My lords, I am the petitioner in item 63.
Yes.
I am the petitioner in item 63, my lords.
Yes, it's only stay order. Stay order.
So, my lords, I filed this petition specifically in the light of the directions of this High Court and High Court Bar Association versus Allahabad versus State of UP on 29th of February 24.
Grant of stay, ask them to vacate it.
I have filed 4 applications to vacate the stay, but the applications have not been heard. They have been listed with the main case. The main case doesn't get heard.
And moreover, they are all your own relatives, not your own family members.
I have filed 4 applications and I have brought to the notice of the Honorable High Court the orders of this.
You yourself are a doctor, is it?
Yes, my lord.
And the ones who are running the hospital are your own people.
There are. I have filed the complaint against 8 individuals, my lord, which includes the civil surgeon and the DGHS.
Family members' hospital to be closed. What the personal rivalry don't convert it into.
My lords, that has already been taken note of by this honorable court. The orders are annexed at annexure P11 and P12.
Go to the High Court, ask for vacation of the interim order.
My lords, I have filed 4 applications for vacation of stay. They have not been heard.
It is submitted by the learned counsel for the petitioner that application for vacating the interim order has been filed. If that is so, we request the High Court to take on the said application.
My lords, they have been filed, notice has been issued, but they have been listed with the main case and have never been heard.
You have directed the High Court to do. Next.
May it please us. Lord, few dates are important. Lord, this property.
Sorry?
So, after for respond number 1 and 2, one caveat.
Yeah. Lord, this property. Fresh matter. Lord, few dates are important.
What is it against the
Yes, Lord. What happened is this.
This matter came very late.
Yes, Lord. This had come last time also. This had come little late.
Why?
Well, because it got added in the supplementary list. Last Friday it was listed. Again it came very late, and then today also it came probably very late.
Now you tell us.
Yes. What happens is this. This property in Pune was owned by one Gulabrao Kavde.
These against which order?
The registration of the society. This petitioner proposed society was directed to be registered as a cooperative society. In fact, was registered. The original owners, the heirs of the original owner, and to the people to whom he has sold, they challenge that registration. The developer who purchased it, he challenges it after 5 years of the registration, and the High Court allows it. Now that's against that order. We are here. Now what happens is yes, once it is registered, now the other side challenges the original owners, heirs. In fact, their ancestor has sold it to the proposed society, and now they are challenging it. They don't even have a right. That's what I'll try to demonstrate. So this Gulabrao Kavade was the original owner. He executes a registered CD in favor of the proposed society on 13th of September 1994. Please have a look at that.
You just tell us the facts, please.
Yes. Now that property, the total land. The total land owned by Gulabrao Kavade was 10,207.18 square meters, out of which
Okay, come tomorrow.
Where?
Just see the improved judgment.
That's what
it explains everything.
That's why I'm here. That's not correct.
You are telling us like a first of
No, in fact, the application which has been filed.
Starting with Kutubuddin came to India.
Precisely,
by that time.
And so, but I not take more than 3 minutes.
Principal being confused.
No, I'll not take more than 3 minutes.
That society was never formed, it remains unformed.
No, it is registered.
So the property is gone by will to his son.
That's what my beloved record my friend's statement. He says the property has gone by will. I'll show them how it has not gone. And so blind.
Between today and tomorrow, just about 30 days. Right.
May I please? Because there is a delay of 599 days.
One explanation.
Lords.
Again,
that too against an interim order. Tomorrow morning. No,
Well, otherwise it won't reach me.
Irrespective of whether list or not, you are there, you come.
There is an interim order. Lords, yes, a delay of 599 days, Lords. Lords, there is a delay because, Lords.
Yes, an interim order.
No, Lords. If Lords may kindly see, Lords, the order for a minute, Lords. Just for a minute, and then I'll not press, Lords. Lords, it says that the bailor, the respondent, Lords, herein, is in parity with the people, Lords, who have been given a regularized job. Thereafter, their dearness allowances, pay grade, as well as basic.
You're just going
No, sorry, Lords. Lords, with respect to the Lords.
Take things for granted.
No, Lords.
There is 599 days delay.
Lords, to be.
Interim order. What happened to the main matter?
Lords, it's still pending.
Then
it's still pending.
That you coming against an interim order?
Lords, the reason is
passed way back.
In 2023, Lords. Thereafter, the matter was never taken up.
Seek some time to verify.
You don't know whether it's pending or
no, it's pending, Lords. It's pending.
You dismiss it on the ground of delay.
I bow down. But just one thing, Lords.
It's for delay, that's all.
Can't be. Lords, the question of law may be kept open. Why?
Lords, what are you saying? Is interim order what?
No, Lords, because they're pressing on an order which has already been passed by this court. I bow down, Lords. I bow.
Interim order. That's it.
I bow.
Yes, ma'am.
Yeah, it's in post.
See, covered by the judgment, you will have to go to the High Court.
My lord.
You have to go to the High Court against this order.
This was the matter of 29 years old, my lord. And under Article 136, this honorable court has the discretionary powers to entertain, my lord. Because 29 years. Kindly grant liberty. Kindly grant liberty.
Next.
Oblige.
చెప్పండి నాకు రీచ్ అయిపోయింది.
So Mr. Naidu is leading us. Mr. D.S. Naidu, if you see our Milord, he's just outside.
Next Monday.
But there is some urgency for the Lordship's from.
Tomorrow.
But I think he's logged in. Lord, I'll just make this beginning.
Is he coming or?
Yes.
You want it tomorrow? What do you want? You want it tomorrow?
No, actually, he is appearing virtually.
Just ask him to open up. Mr. Naidu, can you hear us? Kuch problem hai. What happened? Password karo. Next.
So sorry.
I had a contract not to erect advertisements not on the bus shelter.
Contract success for how long?
Yes, for 4 years.
And when was this order passed?
No, it is subsisting till
4 years. The 4 years continued till when?
5th March 2028.
2028.
Yes.
Then how? Why did they issue this notification?
That's the grievance with which I went to High Court. Now High Court Milord finds in my favor actually and gives a contradictory finding. The first finding is in my favor. Because I am praying Milords that this should not be allotted in the meanwhile. Milord, the purpose will.
We don't really know. Take out Dusty.
Milord, the purpose will go. Milord, these are bus shelters which are.
No, Mr. Goyal, that unless we will be interdicting, we don't know what stage it is. Have they gone with new auction? How did they have they allocated to somebody?
Milord, I will not know. Milord, the process is going on. That's all I know. Lordship may say a status quo, not status.
Meanwhile.
Please. The petitioners are praying for an anticipatory bail. There is a delay of 3 days. All the injuries are simple in nature. Honorable High Court has specifically observed at para 6 that the injuries are simple. Therefore, ingredients of 109 of BNSS will not attract. There was a civil dispute. Even there was a political rivalry. I can put on condition. I will visit police station. All are from the same village. Para 6 bottom. Injuries are simple in nature, and there was a delay of 3 days.
What say even whether we don't know whether you joined investigation.
I mean, I will join it. I will join it. Lordship may indicate. Lordship may put us on a condition. We will regularly visit police station. Whatever is the concerned police station, we will visit that. Admittedly, there is a political rivalry. There was a civil dispute. There is a delay of 3 days. Lordship may kindly have a page 20 for a moment. Incidences of 19th. It has been reported on 22nd. Otherwise, kindly say for this stage, bottom para 6 I will read. So how this is contradictory, my lord? I will read bottom 6 of para. May I read, my lord? The learned APP produce medical certificates. The learned, I will read 4-5 lines only, my lord. The learned APP produce medical certificate of so and so and so and so. Tawfiq has suffered 4 injuries on left wrist, right hand, abdomen, left side and back, and medical certificate shows that injuries are simple in nature.
Up to paragraph 6, CCTV footage shows accused number 1 armed with sickle, accused number 2 armed with sword, accused number 3 armed with iron rod, accused number...
Para 6 of trial code.
It's not so innocent.
Para 6 of trial code.
Dismissed. Next.
I'm open.
Apologies, I was not there. Matter this flash. What number 2?
What is this?
My lords, I believe this will require some hearing, my lord. So I don't know. It's already 3:45.
Never appointed during that period. How can you get the benefit? Item 40.
Yes, my lords. I am for the state.
Yes, okay.
Yes, well,
It will take time.
my lords, the
Well, I'll prove it will take time.
It will take time.
Lord, is it covered by judgment? 3-4 judgment by the High Court. 3-4 judgment by the
Tuesday, come on Tuesday.
Yes,
What was that judgment? What are those big judgments you are talking about, threatening us?
Yes, no, not threatening. Similar fact.
my lords are keeping
In
it.
my case, my lord, 2 months, 16 days.
Alright.
Shortfall.
No, we have only one question. Keep it in mind and answer it.
Yes, ma'am.
Answer us.
Yes, ma'am.
You were selected in 2000, correct?
Yes.
And
No, I, my lord, joined 18/4/2012.
1 minute, sir. 18/4/2000. From 2000, whatever, from a date before 2012,
Yes, ma'am.
how will you be entitled to is the question.
No, I am not asking for that.
Then?
Here, my lord, 10 years is minimum period.
No, you are asking for which period?
I am asking for my shortfall is only 2 months, 16 days. So whether under 30
2 months, 16 days, you want to take from which period? From
8/4/2012.
Instead of, they have taken from?
They have, it is admitted fact. 18/4/2012, I joined. I superannuated on 31/1/2022. So there was a shortfall of 2 months, 16 days. So whether 2 months, 16 days can be condoned under order rule 36 or not, that is the issue.
We thought you were asking for a.
No, my lord, no, my lord.
My lords are keeping it when?
Here is the judgment I have passed on, my lord. Here,
Ask me a copy.
yes, 3 months, 10 days. One more judgment, my lord, I have annexed here. So High Court says.
The word used is may.
The High Court has condoned, why should we?
High Court.
High Court has done.
36.
So we were under the impression that it was a date prior to his joining.
He is seeking a condonation as if it's a vested right for
The way you have prayed, you have actually.
so it can't be. Manos may see the rule. If Manos are hearing it now, Manos may see the rules. Give me the copy of the judgment.
We saw the rule. Power not so and so upon any condition.
Yes, may condone a deficiency. So Manos, therefore, Manos.
That's why High Court has said you consider that. High Court has not considered. The High Court said consider that.
Manos, we have already the
High Court said consider that.
Manos, may I then in that case, Manos, the tribunals.
Judgment, just see High Court judgment.
Yes.
See, earlier period, if you had asked for, we would not have granted it.
Yes.
Then this much, your government should have that much of a sympathy and heart.
Manos, what happens is doing it for one person is not a problem.
No, not at all.
It opens up the Pandora's box for a state. It becomes so
Two things. This is a case eminently justified. Number one. Number two. Even otherwise, the High Court has said just consider.
Manos, we have already considered the tribunal directed. We consider.
Cases
Allow me a moment now. Allow me a moment now.
Thank you.
Manos may say then that it will not form a precedent. That much relief.
We are not inclined to interfere with the order passed by the High Court in the facts and circumstances of the case. Special petition is dismissed.
Manos, one thing may I say then,
the question of law raised by Madhumita
Bhattacharya.
Open for being considered in an appropriate.
My lords, what had happened in another matter, my lords had dismissed it, saying in the peculiar facts and circumstances of the case, we are not inclined. Now, there is a judgment which has come from Calcutta High Court, my lords. I am in the process of filing the appeal. They have deciphered this line that in the peculiar facts and circumstances means that my lords have considered it appropriately. So, I was only requesting if my lords says that this will not form precedent. I mean, it should be more clear because this has been interpreted in this manner and I am in the process of filing an appeal
that is why when you keep on asking for things like that, it will happen. There are judgments of this court which says dismissal of a special petition is not a precedent. If we just dismiss it, it would have not become a precedent. But if you keep asking, add this line, add that line,
I understand,
it shall be dismissed.
My lords,
that's better.
my lords may say that the question of law is left open. That
my lord, in another case,
citing some other.
My lord, in another case, we own here, and my lord have said another case, we have not expressed anything on merit, but send back to the authority. Authority said, my lord has said anything not expressed on merit.
Therefore, it becomes a problem. Whatever my lords Manos may leave the question of law.
Supreme Court should not utter a word more than what is required.
So that's what we learned
Then
by
you are under, you are
our practice.
you are realizing more and more that we are under the trap because you keep asking and asking and asking. We end up passing orders like that, and you will come back for non-compliance. You will file contempts. What
May
not?
I ask for a last thing then? Question of law may be left open. My lords have already dictated.
All right, on the same order.
Right. So
May I please, Millets, I apologize for the inconvenience, Millets. Millets, a sales certificate.
Which certificate in your
Placing it on the record
in
book 1 of the registrars. I am the auction purchaser, Millets. I wanted to. And Millets, last 4 or 5 years, Millets, this is one provision, section 89, subsection 4 of Registration Act, that's been giving employment to people like us. Millets, let's take the example of Millets Madras High Court. Whoever has an auction certificate must come to the Honorable High Court, fight, get a direction, then only they'll place it. And I've had a compilation, Millets, where out of 200 minimum, I've given 12 instances, 9 of them by the Honorable Division Bench. And my lords, on 3 occasions, in the recent past, I've held that one. If somebody wants to go for registration, it's an entirely different thing. If somebody wants to place it on record, simply sit there, don't insist on anything. 3 judgments from your lordships. Millets, they say, Millets, the matter has been seized up by your lordships. That's what we are not. Millets, the learned single judge has held in my favor. The learned single judge has held in my favor.
What are you aggrieved against?
Para 6.
Could my lords come to that para 6 Millets in the impugned order?
Is there any pending matters?
Yes.
Yes, Millets. Here before your lordships.
Post along with that.
Millets. My lords may kindly post that one, Millets. Meanwhile, subject to the outcome, Millets, let me have the certificate presented to them. And Millets, I have given the compilation, Millets, if my lords want to peruse.
Notice, Mr. Take a notice, take Dasti in addition.
Yes, Millets.
Notice this.
Millets, it's coming on 6th, Millets, kindly tag it.
Post along with that.
Great.